notice,
Yes, yes.
please, so that they know, because they can't, by simply reading, they're unable to.
Okay, sir. What's oblige?
Yes, please.
My lord, fresh wakalat has to be filed. I have intimated I pray for only short date. So file a fresh wakalat, but I cannot appear. They have requested me today. I pray.
Charter date कर दियो.
With counsel 27/7.
27 week रे आसीबो.
Again, my lord, my lord.
Yes.
Item number 3, permitted to withdraw.
Yes. Mr. Patnaik.
Aye, my lord.
Yes.
Page 2.
Item 7, my lords.
7 to 14.
Item 7, may I pray 2 weeks after, my lords? I need further instruction in the matter, my lords.
State. 7. State to take instruction with regard to prayer made in the transfer petition.
No instruction has come.
अच्छा. अपन केबे चाहूछन Mr. Raut?
Any date 2 weeks after, my lords, or any date as per lords' convenience, my lords.
27 week.
My lords.
Yes. Simply posting 27 ta posting कर दिया.
Right.
Order that. Mr. Lenka. Yeah. Other side has appeared.
Instruction that I'll inform to the.
Yes, sir.
Compromise is going on. The meantime, judge also pays certain amount.
When do you want, sir? Whatever he has paid, ask him to file affidavit.
Yes,
Yes.
I'll inform Mr. Nath.
But since he has appeared on these matters, maintenance matters, you should hear you should also hear it. Apart from me hearing it. You ask your junior to be there. Date केबे कहले?
With counsel 3 yet.
We commencing 3 ही आटे. Yes. 9 ରୁ 14, then 15 ରୁ 22.
My lord, I am in this in item 19. I am for the opposite party. I have informed the petitioner for adjournment of 15 days as we are talking to decide the matter amicably, my lord.
अरे सिर्फ petitioner absence रे आपण mention करछोंती ना.
My lord, I am for the. I am for the.
I will arrange a conference, sir.
I am for the petitioner.
Yes, Mr. Mishra, he seeks adjournment.
My lord, there is no difficulty. He has in fact requested me, but the
Okay.
thing is that your lordship on 10/4/2026 directed both the parties to come to a settlement on mutual discussion basis.
Yes.
I tried my best. I called him thrice.
So keep
Now
on
let
trying.
him,
Keep on calling.
let him.
After your call is responded, then keep on trying.
My lord, he has responded of late, though late, but he has responded.
Better
Now
late
let
than
him-
never. Better late than
My
never.
Let them assure the court that some
No,
amount.
I don't seek any assurance.
My lord.
That kind of approach is contrary to the concept of mediation. Read that Supreme Court decision, where in mediation court tries to impose its views.
My lord.
Court has definitely a role if merit adjudication and is concerned.
Well.
But if we try to interpret the way we want, then there is no mediation. There you have to be careful, Mr. Mishra.
My lord.
Don't go, you may, very rightly you may think that something is better or something is not better. Still worse. What you call in a scale. But it is for the parties to decide. Even if they agree for a worse settlement, let them agree. It is their choice. So you have to have the role of a facilitator.
My lord. My lord, we are trying a lot. Call
Yes,
because
work on this.
my lord, there is a petitioner is a woman. She is suffering because of financial problem. Your lordship, 1 week time may be given. Let him say. We have already discussed. If some conclusion can be arrived, or else your lordship may decide.
This WPC is for what? Challenging what?
That is for enhancement. The husband is getting 4 lakhs per month. There is an award of 15,000.
She is not getting anything.
I am getting 10,000. I have filed, my lord, asset liability affidavit with my all salary particulars. He is not filing. He is not filing asset liability affidavit.
So that I cannot become the
Yes, Your Lordship. I agree.
See.
Since he is requesting
let
for
us
a
see, let
time.
us see. Let us see ଆପଣ କେବେ ଆଣିଲେ ହବ?
এটা ଗୋଟେ ସପ୍ତାହ ଆଜ୍ଞା ଦିଅନ୍ତୁ ସେ ଟ୍ରାଏ କରନ୍ତୁ ଗୋଟେ ସପ୍ତାହ ଆଜ୍ଞା ମତେ ମୋ ପ୍ରେୟାର ହଉଛି ଗୋଟେ ସପ୍ତାହ ଆଜ୍ଞା ବିକଜ ହି ଇଜ
ଦି
ରିକ୍ୱେଷ୍ଟିଂ
ସପ୍ତାହ ନିଅନ୍ତୁ, 2 ସପ୍ତାହ ପରେ କରିଦିଅନ୍ତୁ। ହେଲା? 19 ରେ ସେ ଅର୍ଡର ଲେଖା ହବ। ଡେଟ୍ କରନ୍ତୁ ଆଜ୍ଞା, ଜଲ୍ଦି କରନ୍ତୁ ଆଜ୍ଞା।
Utkamji 13/7.
13/7 ୱିକରେ ଆସିବ।
ଆଜ୍ଞା ଆଜ୍ଞା
Yes,
I
next.
also request him to make some sincere effort not
Yes,
to
my lord.
Again, you are becoming judgmental. That you
No,
are
my
the
lord.
only sincere person who is sincerely pursuing mediation, and Mr. Swaroop is not that so sincere.
no he is my younger brother Your Lordship.
That is the often we make that. It's not a mistake actually. It's very usually we get it that way.
He is a younger
Becomes,
brother he is also trying my lord.
more subjective than objective.
My
Yes.
lord obliged Your Lordship.
Page 4, 23 to 27.
7.
Yes, please.
Paper 3 also.
How much you have deposited? How much money you have deposited?
Item 27.
Yes, you are the petitioner. You are challenging what?
Challenging the expert order of the.
Or dismissed? Dismissed.
No, sir.
Sir, this is not a place for taking chance.
No.
First innings, second innings, no. The message is loud and clear. Either you pay or get the RPFM dismissed, go to Supreme Court.
He already paid the amount at the time of.
File that affidavit. Here you are not having a chance that there's quarter final, here final.
This occasion you.
Sir, talk law. No common sense. No common sense arguments. Have you paid? What is the amount directed? What is the default? What is the default?
Defaulter is not filing execution proceeding and that.
What is the default?
Default
What is the default? If you do not know those things, you are not prepared in the case.
No, Millards, because.
What is the defaulted amount? I can tell you in seconds. Did you bother to look at the brief?
Yes, Millards.
So prepare. Or else I'll dismiss it today, I can assure you.
Yes,
This kind of hide and seek doesn't do Mr. Das.
Millards. Previous occasion, your lordship has told that you submitted the certified day-to-day order sheet of the lower court order, day-to-day orders. Because the.
Sir, what you are saying? What you are saying, sir? I have not passed any order.
No.
Sir, any order I have passed is on record.
Your lordship report regarding the.
I have a difficulty in forgetting even if I have not recorded. I have not passed any such order. So don't ask that because I have passed the order and so that is how you are taking the time.
Submit before your lordship court. Previous occasion, I submit before your lordship.
Sir, let us not go there. Go to the order dated 5/5/26. Go through that. Why you are standing and not going? It is your matter you are mentioning. Look at the order. That reading. What you are doing? Why you are scrolling it? Assist karo.
Yes, I felt
Start reading. All out कौन लगा इसे बहुत? Sir, not muted, sir. This is a courtroom. You have to read it aloud.
Yes.
You have mentioned I am giving you time. So, what? Yes, I have not dictated any yes. Start reading the order.
petitioner husband in the marriage is before this court.
Past is very important. Learned counsel for the petitioner is hard at some length.
Passed by the Lawrence Judge Family Court, Kedrapada in criminal proceeding of 207 of 2022. Said proceeding was
You are
initiated.
reading so fast that is why you are unable to remember.
Yes,
And you are attributing something to the court which is not there.
Sorry, my.
I am very sorry that you should do this. The said proceeding was
initiated under section 125 CRPC since repealed and substituted.
Bracket chhad diyo. Bracket is not important.
Prior to filing of the application under section 125 CRPC, the present petitioner husband had initiated divorce proceeding under section 13, surplus 1, surplus IA of the Hindu Marriage Act against his wife, present opposite party, and that is CP case number 300 of 2025, which was dismissed on contest. The petitioner was receiving 13,390 per month towards maintenance, which was stopped by the letter dated by 24/9/2022. Is submitted by the Law and Counsel for the petitioner that the petitioner is not aware of the judgment dated 8/7/2025. Perusal of the judgment of which revision is sought or indicates that notice on the petitioner hearing was sufficient. For the reasons best known to him, he has not stated regarding the notice received from the Law and Family Court in his present application seeking revision which speak volume about his conduct. It has been observed by the Law and Family Court that after receipt of the notice, since the opposite party husband, present petitioner did not appear, he was set ex parte in the order dated not.
Bye. ভুল হওয়া কথা এটা ভুল হয়েছে বাই দ্য অর্ডার এটা আমার বি ভুল হচ্ছে ভুলভাল ইংলিশ
Yes, ma'am. On being asked, the Law and Counsel for the petitioner submit that he has no instruction whether any application was filed for recall of the order dated 9/10/2024, setting the present petitioner ex parte. Prima facie, the plea of the not being aware of the judgment is unsustainable in the facts and circumstance of the case. The Law and Court has taken note of the fact that the present petitioner is working as a havildar in Indian Army and gets salary of 60,000 per month. Apart from that, he has 6 acres of landed property of which the record of rights were produced and marked as exhibits before the Law and Trial Court. Other exhibits were marked and proved before the Law and Trial Court regarding the property owned by the family of the petitioners himself. Law and Counsel for the petitioner is apprised the judgment of the under.
Leave it there 7
Yes,
so there's no point in 8 Not a counsel for the petitioner 6 as adjournment.
Yes.
So where I have directed the doctor copies of the order sheet. So don't say that.
No. I submit before a lordship court regarding the because
So you make your submissions right now and pass the orders, or when the matter reaches, it is your choice. That much of intelligence I can show, I will take up your matter out of term. Because I can't waste time. That is how that day I heard you and passed a 4-page order. Today I am not waiting for you to take adjournment and again another. Yes, you deposit the amount or the matter will be dismissed.
taking instruction from the petitioner.
Tomorrow. You keep on instruction, but court is not with a begging bowl, Mr. Das.
Because
Neither the lawyer.
Yes, my lord, because he is serving at.
Wherever he is serving, sir, it is. I will ask the. Do you want that the army will be involved in this?
No, my lord. I
Please
take
understand.
instruction from-
Don't create problem for him. If I direct the Director General this defense or accounts, that will invite him for more trouble. Usually, you will see that the private sector employees they don't want that the employer should know about these things. Sir, court is not here to go with a begging bowl.
No.
So please do that.
Sorry, my lord.
And not sorry. Why you should be sorry? You should not do that also. You talk to your client in terms of law. That will enhance his respect for this. You are not supposed to say more dabar nahi apan jahan to jaha karibe. That is not your job.
I take instruction from the.
No.
petitioner.
I'll direct about freezing of his salary. No difficulty.
But I want some times for.
You have been given enough time, sir. You have been given enough time. Look at the time you have been given. How much time you have been given?
Weeks, my lord.
2 weeks you have been given.
No, my lord.
You have been already given 8 weeks time. Yes, next. Page 528 to 32. I'll record and pass that order.
Yes.
I'll direct the DSGI to obtain his salary details and how.
Problem.
Page 33 to.
Then he may respond to you. If he's not responding to you, you have to run after him because he works in army. So now he will respond to you wherever he's working.
Usually he paid the amounts. That is the stop.
Who stopped? Who stopped?
Petitioner stop the
The Supreme Court.
petitions.
The petitioner is the Supreme Court or what? How he can Havildar in army becomes a Supreme Court? You will sit over judgment of a family court.
He paid the amount.
Sir, that is the tragedy, Mr. Das. You are treating him as Supreme Court, but I have to treat the family court as a family court.
Sorry, my lord.
I am extremely sorry, Mr. Das.
Yes.
I am extremely sorry.
Because he had paid the amount. Previously, he paid the amount.
Sir, instead of making a speech, you state that in an affidavit. Who is saying that he is paid, whether he has previously paid or not? The question is that if he remains in default of the judgment, that is the issue. Why he will not respond to court's notice? Havildar. So whoever, however so high, his law is above him. And in 24 he did not challenge. He was set expert. In 26, because execution has been launched.
It has not been.
Execution has not been launched. You see the situation. A lady goes to court. He does not get anything. And then you come to High Court.
So you want 2 weeks time for.
So I noted that you are praying for 2 weeks time or rejected. Because already you have been granted 8 weeks time. 5-5 to 5-6 is 4 weeks. Then for 5-6 to today is 36. There is a context, mister. There is a context of everything. It's better you, Mr. Das. I'll deviate from my normal rule. I'll pass the order now. The matter being listed for orders is mentioned by the, this is item 27. Matter being listed for orders is mentioned by the learned counsel for the petitioner at the beginning of the day's proceedings, seeking adjournment. Further 2 weeks adjournment. After the order dated 5/5/2026, already so many days have passed. That is around 4 weeks, 8 weeks, 7 weeks. The prayer for further adjournment is rejected. The copy of the order dated 5/5/2026, along with today's order, shall be served on the learned DSGI, who shall obtain the details of the employment of the opposite, the petitioner Sri Gyanaranjan Mahanti. Pura likhibe. His employing authority, drawing and disbursing authority. Stop. The present order is passed in view of the submissions made by the learned counsel for the petitioner, that the petitioner is not responding to his when he is contacted. The learned DSA shall also apprise this court whether in the present place of posting, the petitioner cannot attend the court cannot attend the court when he is the petitioner himself due to exigencies of his work. Such instructions shall be provided by the appropriate authority and public employer of the petitioner. Yes, the matter shall be listed in the week commencing. Listed in the week commencing 13/7/2026. Yes, next.
Item 1.
Party करचंदी. Mr. Nirmal Chandra Mahanti for the petitioner. Mr. Prem Kumar Mahanti for the additional standing counsel for R1, the petitioner, no appellant, the appellant. Mr. Jayananda Mahapatra along with Mr. M.R. Pradhan for R2. Mediation ପାଇଁ କଣ କୁହନ୍ତୁ ଟିକେ ଚେଷ୍ଟା କରନ୍ତୁ
କପିଟା ଟିକେ ନାହିଁ ତ ମୋ ପାଖରେ କପିଟା ଟିକେ ଗୋଟେ କପି ଦବା ପାଇଁ
କପି ନାହିଁ
ନାଇଁ କପିଟା ନାହିଁ
Lord Counsel for the
Last date ରେ ବି
R2 requests for appeal memo along with all the connected papers stating that though as directed by order dated 10/3/2026 the BDA has been included as a party included as R2 but no copy has been served. ଦି ଦିନ ନା କେତେ ଦିନ ଲାଗିବ 3 ଦିନ the Lord Counsel for the appellant shall serve extra copy of the appeal memo along with all papers on the Lord Counsel for ଆପଣ ପାଖରେ କପି ଅଛି ତ Mr. Mahanti?
yes yes
The Lord Instructing Counsel Mr. M.R. Pradhan for the R2 within 3 working days. କେବେ ଆସିଲେ ହବ Mr. Pradhan?
ମାନେ କପି ଦେଇଦେଲା ପରେ ଗୋଟେ ତାପରେ ସପ୍ତାହରେ instruction
The Lord Counsel for the R2 shall obtain instruction regarding the parties agreeing to a mediated settlement. The matter shall be listed under the same heading in the week commencing 20/7/2024.
Item 2,
My lord, the copy of the consolidated cost title has already been filed. May it be referred to
କେବେ
the
ଫାଇଲ କଲେ
mediation center?
ଫାଇଲ ହେଇଛି ତ କପି ସର୍ଭ ହେଇଛି
Yes, my lord, this is the receipt.
କାହାକୁ ସର୍ଭ କଲେ ସୁଧୀର ଚନ୍ଦ୍ର ମହାନ୍ତି for the appellant, the Prem Kumar Mahanti for R2 and 3 both R1 and 2. Consolidated ଟା କୋଡେ ଆସିନି ଆସିଲେ ନା ଅଛି ନା ତଳେ ରଖିଦେଇଛୁ କଷ୍ଟ ରେଟ୍ ତଳୁ କେମିତି ରଖିବେ ଆପଣ କଣ ଲାଷ୍ଟରେ ଆପଣ ରଖିଦେଲେ ପୁରା ନା ପିଟିସନ ପୂର୍ବରୁ ରଖିଛନ୍ତି मेमो पर इंडेक्स ऑफिस नोट इंडेक्स मेमो ठीक है पता है ठीक जगह रखो for the respondents Supreme Kumar Mahanti for the respondent ଆପଣ କଣ କପି ପାଇନାହାନ୍ତି କୋଉ ପାଇନାହାନ୍ତି Mr. Mahanti?
receive the copy
Also copy of the consolidated cost title you have received. Office note indicates that the consolidated cost title has not been served on the opposite part on the respondents stuff. It is submitted by the Lord Counsel for the Lord Additional Standing Counsel that he has received copy of the consolidated cost title. The office note declaring compliance is satisfied. Stop. Mediation called Mr. Mahanti.
I've sent a letter but no instruction has come
The matter is listed under the heading for referral to the special mediation drive 2.0 mediation for the nation. The Lord Additional Standing Counsel submits that he has sought for instructions from the respondents and seeks for the time. Accordingly, the matter shall be listed under the same heading in the week commencing
20/7.
20/7
3/8 karo.
3/8 week commencing 3/8. Yes, please.
Item 3,
So Sunil Kumar Patnaik for the petitioner. The revision application has been filed that Thibo Abu order Thibo. The revision application was presented before this court on 16/3/2021. As there were defects in filing, it has been adjourned since 21/11. It was adjourned on 21/11/25. Granting time to remove the defects on 6/3/26. Further time was granted for removal of defects. On 9/4/2026 was the following order was passed. 9/4/2026. On 4/5/2026, the following order was passed. Stop. Today, the matter being in the list, the matter having been listed for fresh admission, memo of date is filed, which states thus. Stop. Appendix, the memo is taken on record. Scanned copy be updated. In view of the above, the petition stands disposed of. Copy of this order shall be forwarded to the learned judge family court, Palesur. Palesur to be kept in the records of CRP 252/2010, disposed of by judgment dated 23/3/2020, arising out of CRL dot miscase MISC dot case number 187 of 2008. Yes, registered to do the needful now. Next.
Item 4.
Right. But order to kare padibo na. So Aurobindo Mahanti for the petitioner. Party Mr. Prem Kumar Mahanti for the students. It's not a plural. It's a board petition. Petitioner Jordan. Aurobindo Mahanti for the opposite parties.
I am for 1 and 2 only.
Brief देखिले एटा कौन भूल भाल अछि?
No notice has been sent.
Read देखोची 1629 of 2020. एटा किंतु 162 ऊपर देखोची 2021. This 2021. ठीक अछि. ताका लेखिवा बोली टाइप करे. The learned counsel for the petitioner mentions the matter referring to the order dated 15/4/2026, wherein liberty was granted to the petitioner to engage any other counsel. Stop. Further time is sought for by on behalf of the petitioner to engage any other counsel, any other learned counsel. Stop. The matter shall be listed for fresh admission in the week commencing. As prayed for, the matter shall be listed in the week for fresh admission in the week commencing 27/7/2026. Yes, next.
Item 5.
Ms. Sujata Jena, senior advocate, along with Ms. S. Ponda for the petitioner. Yes, please. Opposite party, black. Yes, please.
I am fully also finished my application was rejected. The area of maintenance is concerned. On the ground that permanent aluminum has already been fixed.
সেটা মানে জনা পড়িলা কি যে সে যে 125 রে অ্যামাউন্টটা সবসিউম হইছে কি নাই তার হিসাবে
Se এই পথটা আমরা মাটারে যে অর্ডারে লেখাই হচ্ছে এই কুইলে আর্টিস্ট
নে অর্ডর জন্য তো লেখা ହେଇନି বট ଆପଣଙ୍କର ସେ ଯୋଉ ଗୋଟେ କଲମଟା ନାହିଁ କି ଯୋଉ ଆଫିଡେଭିଟ ରେ ଅଛି ଏନି ଅଦର ଆମାଉଣ୍ଟ ପେଡ୍ ଯେ ସେ ସେଇଥିରେ ଅଛି କି ସେଟା ଟିକେ ଆପଣ ଦେଖିବାକୁ ପଡିବ ନହେଲେ ସେଟା ଜଣା ପଡିବ ଇଏ ଦେଖନ୍ତୁ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ତାର ଆଉ ଗୋଟେ ପ୍ରୋବ୍ଲେମ ହଉଛି ଯେ ଯେଦିନ କେସଟା ପେଣ୍ଡିଂ ରହିବ ଆପଣଙ୍କ ମାନେ ପିଟିସନର ୱାଇଫ ଭାବିବେ ଯେ କିଛି ମିଳିବ ବୋଲି ବଟ ସେ ଜାଣିବା ଦରକାର ଯେ ସେ ତାଙ୍କ ଆମାଉଣ୍ଟଟା କଣ କନସିଡର ହେଇଥିଲା କି ନାହିଁ hard adjustment
judgment ଅଛି ବି ଆମ ଯଦି specific order then as soon as adjustment is concerned then I am entitled to get it.
divorced wife is entitled
No, that is if I find subsequently. That is
even so then the argument in response should be for the husband is that I have already paid alimony. That's a different thing. But here since we are not very sure actually what exactly happened.
because the order was passed. Maintenance order was passed long before.
Yes.
So
So now after the Supreme Court has specifically laid down the guidelines, whenever any maintenance order is passed, whatever not adjusted has to be taken note of.
No,
But it can't be that 5 courts separately will start that should not. So that adds to confusion also.
yes.
Judicial confusion is a problem, of course.
That's
And this is Bhara Panch Teisi. So it is after that Supreme Court decision in 21.
yes.
Hard learned senior advocate for the learned senior counsel for the petitioner. Seeks further time to obtain instruction. In terms of the earlier order dated 11/5/2026. The matter shall be listed for fresh admission in the week commencing. Satish. Satish.
Item 6,
6. I'm for optimal. Usually possible corridor, but since you are there, so petitioner none, Mr. Akshay Kumar Pandey for the opposite party. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing, for fresh admission in the week commencing.
Odisha.
Odisha.
Item 8,
So Niranjan Lenka for the petitioner, Mr. Suryakanta Das for the opposite party. Anyone present on behalf of Mr. Das? Upon Ochandi? Kindly have your seat. It is submitted by the learned counsel for the petitioner that the parties to the present petition are in the process of mediation and settlement. Stop. It is submitted that the petitioner has paid certain amount to the opposite party in terms of the direction. Contained in the judgment and order dated 11/2/2025 towards maintenance. Stop. The petitioner shall file affidavit giving the details of payments made, such as date of payment, amount paid, mode of payment, pursuant to the direction, pursuant to the judgment dated 11/2/2025. The matter shall be listed for fresh admission in the week commencing 3/8/2026.
Item 9,
Yes.
And for the petition,
You are Mr.
Devi Vastellara for petition.
Item 9 ଆପଣ power नहीं धीरेन्द्र कुमार महापात्र PK Satpathy.
On behalf of Mr.
Mr. Das, Mr. Lenka mentioned the matter for adjournment.
in fact, he has asked me to.
No. So I have marked your presence because he mentioned on your behalf. So obviously, and you are not there.
In fact, I was saying my senior,
Yes.
that neither the lawyer nor the client, no one is responding.
Okay. I have simply adjourned it. He says that there is a process. They are in the process of settlement and mediation, and he submitted that some amount has been paid.
Yes.
Let that affidavit be filed.
Yes, they're better.
Think
Because
that-
my lawyer at the local bar, he is facing very embarrassing situation. Sir, you are giving call after call, that she is not responding. What to do? These are all part of.
That is what happened. That is what I mean. Usually, the
confidential
wife is has lost confidence in the process. ସେ କଣ ମେଣ୍ଟେନାନ୍ସ ପାଇଁ ଗଲେ ତାପରେ ସେ ଏମିତି କେସ୍ ଚାଲିଲା ଯେ ତାଙ୍କର ଅବସ୍ଥା ଯୋଉଟା କି in fact it has been observed in Rajnesh after 7 years finally something has I mean she has got. Yes, please.
I may be permitted on behalf of Mr. Mahapatra, Lords.
Vibhu Vaschalya,
Devi Vastellara, Devi Rath.
Mr. Devi Vaschalya Ratha on behalf of Dhirendra Kumar Mahapatra for the petitioner. Affidavit dated 17 as directed by 17 not filed.
Yes, Your Lordship, we have the instruction, we'll file the update in between some time, if some time will be granted, Your Lordship.
And sometime মানে
Within a
15
week or so, Your Lordship.
15 to 2 months and
Your Lordship. Actually, in the meantime, the petitioner is paralyzed, Your Lordship. And petitioner's
paralyzed or not
pe-
paralyzed,
pe-
that is not important.
petitioner's son is to arrange
Because plea of paralysis is a risky plea before this court. Because somebody took that plea and he simply what he did when the police met him, he rode a scooter and went to the hospital. But the saving grace is he was thoroughly examined and he was treated by court's direction.
Your Lordship, actually, the petitioner's son.
Anyway, sir, we are not negotiating. We are not here
Just
to negotiate.
1 week time. If
No,
you
let us
can-
see that later.
Actually, Your Lordship has directed to obtain instruction regarding how the petitioner will secure that amount of 2 lakh, Your Lordship.
ଟିକେ ଆପଣ ରହିଗଲେ ଭଲ ହବ.
Right.
It seems I am better prepared than you, so that you are not following anything. And definitely I am not against you. যেহেতু Mr. Das মঝিরে আসিগলে, so there was interruption. So what I was saying, so that is how. So by order dated 17/4/2026, the following was directed. Should I quote करते हुए? Thereafter, on 7/5/2026, the following order was passed. Mr. Lenka is there. There is a direction to serve copy. Dated 16/4 along with copy of order dated 17/4. Mr. Mahanti. There is an order to serve copy. You have the brief.
No.
To create a brief, otherwise there will be a problem. How will you trace the file then? ଆପଣ ଯୋଉଡାକ copy serve ହଉଛି, how do you handle that? You have to create a brief, at least. Otherwise, it will be lost. You talk with Mr. Lenka.
My lord,
It shows that it has been served on Mr. Lenka.
Mr. Link.
As directed earlier by this court, the copy of the affidavit dated 16/4 along with copy of the order dated 17/4/26 has been received by Mr. D.N. Lenka, learned AG. Learned Additional Standing Counsel, Mr. P.K. Mahanti seeks further time to obtain instruction from the DCP Armed, Odisha State Armed Force, 7th Battalion, Bhubaneswar. ସେଥିପାଇଁ actually ଆପଣ ତ ଏଟା ମ୍ୟାଟେରିଆଲ ମ୍ୟାଟର ଆପଣ ସେତିକି ଖାଲି ଦରକାର ଇନଫର୍ମେସନ ଦରକାର ପାରା.
Talk to Mr. Lekam.
Yes, he might have sent later, but you have to have the file, otherwise how it will be. Pursuant to the affidavit filed on behalf of the petitioner through his son, the following direction was issued at paragraph 9 of the order dated 17/4. Thereafter, no affidavit has been filed. Though sufficient time was granted till 4/5/2026. Thereafter, the matter was again adjourned on 7/5/2026. And again, the matter was adjourned by the petitioner on 7/5/2026, and the execution case was directed to be adjourned beyond 6/7/2026. The interim order, the interim direction directing adjournment of the execution proceeding is not extended. Copy of this order shall be forwarded to the learned court in season of criminal CRL.ex.p. number 158/2025, arising out of judgment dated 17/6/2025 in CR.p. number 304/2019. Pension is paralyzed?
Pension
is not paralyzed. And account is paralyzed?
No.
Okay.
Your Lordship, he will secure the amount.
I don't know.
Your Lordship, he filed the account.
I don't know. Sufficient diligence.
Lordship, if you
Today, at least there has to be uniformity, because other matters I have not adjourned. 17/4 ଆପଣଙ୍କର ହେଇଗଲା ଜୁନରେ 2.5 ମାସ ହେଇଗଲା.
if I may pray, your Lordship. Your Lordship, if your Lordship will fix it to
Why should
8.
you pray? You should not. You are not seeking any favor.
If your
So
Lordship,
you have achieved, you have deferred the matter as a lawyer for almost 3 months. We'll be approaching,
if 1 week time may be granted, your Lordship will positively file the affidavit, because he is.
it's not a question of positive or negative. You have forgotten that his son is not paralyzed. You have to be careful.
Your Lordship, in the meantime,
Already his son has started participating. That I have
Your
said.
Lordship, in the meantime, in between 2 months, the son has been shifted his job, your Lordship.
He's also paralyzed.
No,
So let us see that his
he has been
grandson may
terminated
be
from his
paralyzed.
job, your Lordship.
Fair enough.
That's right.
Good strategy. With paralytic strokes to the son and 6/4 ଆପଣଙ୍କର 6/7 ହେଇଯିବ. You have achieved.
1 week time may be granted.
No, you may take 1 day or 2 weeks or 3 weeks. It is immaterial. The matter shall be listed for fresh admission in the week commencing. Or 30. The week commencing 13/7. The learned additional standing counsel, the learned AG shall obtain instruction. Copy of this order shall be handed over to the learned AG, Mr. T.N. Link.
Can I pray, your Lordship? Just any day before 10th, your lordship will file the affidavit and submit before your
Is
lordship.
it auspicious?
No, your lordship, the 10th, the execution proceeding is fixed 10th. your lordship.
It doesn't matter, sir. That order has been recalled.
No,
It will be intimated by the registry.
No, before-
Order shall
before-
be, the order dated so जोटा थिला is not extended to डाकिची बोले. ठीक है.
Any day before 10th.
And God forbid the judge will not have a paralytic stroke. 6-4. He'll be able to pass the order in the execution case. এটা আগে ফেব্রুয়ারি চালছি paralysis ফেব্রুয়ারি হেলানি that is the reason आपण जो कोण हालती the process is in paralysis तारीख पे तारीख this is the classic example that for 6 months almost now that मास जून पर जुलाई पर अगस्त ही 6 months
Made it possible before 10th.
sir it has been posted today the order is communicated tomorrow they will act so 10th will not help you are you a little bit disoriented because you are not that you are quite sharp you must understand what I have directed today the order is recalled so it will be communicated tomorrow so what about 10th tomorrow is कल तो 1 तारीख और 10 रे कोन था हो
10 रे से फिक्स करछन्ती
से जो 1 ରୁ 10 भीतर आपण फिक्स करंतु
1 ରୁ 10 फाइल कर
आपण 1 ରୁ 10 भीतर फिक्स कर दे परिए
within a week we can file.
अरे क्या विदिन अ वीक आपण बुझ परिए 1 ରୁ 10 केते दिन 10 दिन आपण वीक टा हेलानी ता भीतर
But if your lordship puts the matter to 13th, then we cannot. It cannot be taken up here, your lordship.
आपण बुझी परना it will be taken up by आपण कोठी फिक्स करिवे
We'll file the affidavit and put submit before your
पेटी डिपॉजिट करो the problem is that once I direct that आपण का paralysis भी काम दबो because if I will direct then court will not have a option कौन से डिटेल्स आनी दियो that will help the lawyer also फेब्रुआरी मास से गोटे केस हैंडल कर पाम ना कि आपण कथा सुनिबेनी आग ताकर पैरालिसिस हला फेब्रुआरी कतन पुओ पळेले this saga will continue the lawyer is at his wit's end
Today only he is making the deposit, your lordship. That's why I want a week.
very good so today this order is not the last order so that you have to go to Supreme Court there are so many possibilities you see how they are what they are doing आपण 7 दिन केनते टुडे केनते हला because they passed the order maybe आपण फोन कले से आपण को सैंक्शन डिपॉजिट करी कि कॉल करी
से आज कहि छि त
से ही जीव।
क्लियरेंस पे ही रखु छि दीदा
you are not his agent to take chance बुझली you are a lawyer आपण तो लॉ एक्सप्लेन कले से आपण वाला सुनु ना कोन कराय लास्ट मैटर डिड यू हियर मिस्टर दास ताकू सी फोन करछनी लोकल काउंसिल व्यस्त जायगा से मगता कि मते रेस्पोंड नहीं करूना सिम्पली काहे हो कोन दरकार ताको इंटरेस्ट आगा केस करिवे न करिवे आपण कोन ताकू परसुएट करिवे आगा केस ता टिके भल रे करंतु लॉ टिके अवॉइड करंतु ता होई परियो दिस इज चॉइस सर why should you more कहा था जे do you feel that you are responsible for the situation you are no way you have done your best that's it yes Mr. Tripathi
Item 10.
Data connected application
My lord, in the connected matter, my lord, I am for the petitioner.
yes so
And in the first matter, my senior.
are not available
No, my,
you will be arguing in receipt
my lord. Today, my lord, let them serve a copy in the RPFM case, my lord. The first matter, my lord.
they have solved you the copy okay so Amitabh Tripathi for the petitioner The matter was had at some length on 23/4/26. The following order was passed. Thereafter, it was adjourned. The matter was had at some length. The following order was passed and the matter was adjourned to 25/5/26. As directed by order dated 25/5/26, it is listed along with the WPC number 21338 of 2025. Stop. You will appear, Mr. Mahapatra.
My lord, I have instruction to appear
Okay.
for opposite party.
The Lord Counsel who appears for the opposite party, being the petitioner in the connected WPC, submits that he has instructions to appear and given some time, he shall file the duly executed Wakalatnama on behalf of the opposite party. It RPFM रे चल चलती तो ऊपर तल करिवेनी but accordingly accordingly the learned counsel for the petitioner shall serve copy of the application on Mr. S.S. Mahapatra, learned counsel, who has instructions to appear. केबे आसिले हबो Mr. Mahapatra? Next week दरकार. The matter shall be listed next week. No, next week actually. 133 ହେଇଗଲାଣି. Quebec shall be listed for fresh admission.
We commencing 13/7.
We commencing 13/7. ଆପଣ 6/7 ଚାହୁଁଛନ୍ତି? ठीक है 13/7. ला पर WPC ता ପରେ लिखिए WPC 2133 of 2025. The matter is listed along with the RPFM 311 of 2025, wherein order has been passed today. Stop. Accordingly, the matter shall be listed in the week commencing 13/7/2026 along with the said RPFM. Here the copy has been exchanged. WPC रे कौन? अच्छा. Gotcha. Copy of the writ petition shall be served on the learned counsel, Mr. Learned counsel appearing for the opposite party in the present writ petition. Within 3 working days or 2 working days.
My lord,
Yes.
2 working days.
2 working days. ऊपर टाइम 2 working days कर दो. Yes.
11.
I interim order to continue in the writ.
कोथरे अछि RPFM रा writ रे.
Writ, my lord.
Writ रे लिखिबे interim order dated so and so shall continue till the next date of hearing. Yes, Mr. Patnaik.
Meet Vigiler said, my lord, I am permitted to not press the application IA 249 as because there is some typological mistake. I filed a fresh application. So I may permitted to withdraw.
249 sir for what sir?
So step in dita file itala setere eta typological mistake thala ma correction न करी सेटको आउथरे fresh कर देते.
Yes.
So 249 may be withdrawn.
Yes, yes.
And so far the present RPFM is concerned, my lord, I have challenged the order dated 30th/10/2025 passed by the Relevant Family Judge Noyagad.
Yes.
In CRLP 41 of 25, directing the present petitioner to pay 5,000 per month.
Yes.
Even though there is evidence, I have filed the asset and liabilities before this.
So show your pleadings. What was your stand before the learned trial court?
My lord, only the pleading
So
that
that-
I am receiving 3,000 rupees.
So it can't be a matter of speech. You have to show that you took that stand before the learned trial court by filing your WS or objection.
It has been disposed of, my lord. Finally disposed
How the
of.
written statement is disposed?
No, my lord. That family court CRLMP, my lord.
Whatever you are saying before here was the same pleading.
My lord.
Was pleaded and show that.
That as because it has been disposed of, I am permitted to file those documents.
No, not permitted. You have to, because there is a revision. I cannot start.
My lord.
Rehearing the matter by your, whatever now you are arguing.
My lord.
Maybe better or worse argument, that's a different thing. But I cannot again rehear the matter.
I file the statements which I
No, you have to demonstrate. When you are seeking this court's interference, you have to show that this was your plea.
But
The
in
court
the
has taken
judgment, my
note of-
lord, in the judgment, it has been also been reflected that whatever I have taken my plea there, that I am serving a labor before the fruits.
लेबर रे आपन मिनिमम वेजेस केते बर्तन 600 टका 1800 18000 टका आपन मेंटेनेंस केते हिच
5,000.
ठीक अछि ताले
3,000.
18000 रे आपन 40% केते हो
नहीं
72000 7200 ना जल्दी हे गेला अरिथमेटिक जल्दी हे गेला
my lord, I am receiving 5,000 3,000 per month.
सेटा तांगनार के 3000 आपन कैपेसिटी केते यू हैव टू सी दोस जजमेंट्स
My lord,
दैट आपन
capacity is more.
कैपेसिटी एवं आपन पेरेंट्स के ऊपर डिपेंडेंट आपन
My
किछि करंतिनी आपन पिला बेलु केबे करनथिले बिकॉज़ यू आर बोर्न विथ ए
No,
सिल्वर
my lord, I have also tried my level best to
5,000
keep in
टका
a rented house.
सो आपन जाबी करछन्ती सेटा सिटी एविडेंस रे अगेन नॉट ए मैटर ऑफ स्पीच आपन ताको
then
बहुत
that
जिंस
has been
देइछन्ती
disposed of.
सुना घर देइछन्ती सेटा नो आपनकर प्ली कोन थिला
As because I am,
आपनकर 5,000 टका रे आपन केतना डिफॉल्ट केते टका हेलानी
no, only after this disposal of this CRLMP, the execution was filed. And in the execution, that was a direction that you pay 60,000 in 4 installments.
देलेन ना नहीं
Start करनो किसी तो
दियंतु
सेतर खाली टिके
हबनी
टिके कमे कर
नहीं मुझे कमे पे बसनी मुझे आई हैव टू एक्ट अकॉर्डिंग टू लॉ कमे करते तो मु मना करनी तथास्तु किछि दियंतु नहीं जानतु ना बिकॉज़ आई लाइक यू सो आई विल पास दैट ऑर्डर सेडा हबन
May I permit that instead of 4 installment, it may
and
be
Mr.
more.
Patnaik, interestingly somehow it was tested before the Supreme Court
No, may I pray that installment may be
आपण को दिए कि 15000 लेखा चार इंस्टॉलमेंट देबे देखि आसुन
टिके कमे देले
नहीं
6 installment.
देगा कि दुकान खोला है नहीं कम किसी करे
Only 6 installment.
ग्रेट पेन आई हैव टू टेल दिस आपण आगे आपण को जो दिन टू डायरेक्शन हेलानी से दिन टू केतरा इंस्टॉलमेंट देले
No, recently I have challenged immediately. I have filed.
चैलेंज कोले बोले कोन छडा हे गेला स्टे हे गेला
No, my lord. I have filed it and
आपण जहां दबा कथा दियंतु आसंतु
they have filed in the month of June. They have filed this petition, which I have
The
challenged.
petitioner before the hard ordered counsel for the petitioner at some length, the petitioner before this court is the husband in the marriage. He seeks revision of the judgment dated, judgment and order dated 30/10/2025. Passed by the learned judge, Family Court, Nayagarh, in CRLMP number 41 of 2025. By the said judgment, the petition filed by the wife in the marriage and the minor child born from the wedlock, seeking maintenance under section 144 of Bharatiya Nagarika Suraksha Samhita 2023, claiming monthly maintenance at the rate of rupees 20,000 per month, was favored. However, the learned court directed payment of rupees 5,000 for the mother and child. No, 3,000 for the petition number 1, wife, and 2,000 for the child. It is submitted by the learned counsel for the petitioner that the petitioner earns rupees 3,000 per month and he cannot pay the amount of rupees 5,000. Stop. Considering the submissions of consider the pleadings of the opposite party, as well as the evidence on record, the following finding of the quality. So. The following findings have been given. Paragraph 10, 11, Apparently, the Learned Judge Family Court has considered the income of the present petitioner not at the rate as suggested by the wife in the marriage and has not granted rupees 20,000 as maintenance. The Learned Counsel is apprised for the petitioner is apprised of the judgment rendered by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, wherein the Honorable Court, the Honorable Apex Court have authoritatively dealt with the scope of revision by this court in orders passed by the Learned Family Court under section 125 of CRPC, paragraph 20. Stop. Regarding capacity oblique incapacity to earn, the Learned Counsel for the petitioner is apprised of the decision rendered in Sobodak Dorpuri. Decision. I have also read it. Supreme Court decision. As held by the Honorable Apex Court, following several earlier decisions, as well as decisions of the several high courts, that a able-bodied person cannot take a plea of not being able to earn. In any view of the matter, rupees 5,000 in these costly days is too meager an amount to sustain two lives, that is the wife and the minor child. The petitioner is in default of the amount as instructed to the Learned Counsel. Since 10/3/2025, the total dues comes to 12 plus 15. 5,000 गुणन 15, 75,000. As directed, the Learned Judge Family Court had directed for deposit of the amount 4 equal installments. Arrear amount of rupees 60,000 in 4 equal installments, starting with 30th day of October 2025. Which has not been complied with. କେତେ ଦେବେ କହୁଛନ୍ତି?
ଦବାକୁ ଅଛି ଖାଲି ଇନଷ୍ଟଲମେଣ୍ଟ 6 ଖାଲି କରିଦେବେ।
ଆରେ ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି, ଅକ୍ଟୋବର ମାସରେ ଆପଣଙ୍କ ଫାର୍ଷ୍ଟ ଇନଷ୍ଟଲମେଣ୍ଟ କେବେ ଡ୍ୟୁ ହଉଥିଲା?
ଅକ୍ଟୋବର
6 ଇନଷ୍ଟଲମେଣ୍ଟ ହେଲେ 10,000 ହବ, ଏହା ତ? ଅକ୍ଟୋବରରୁ 10,000 ଲେଖା ଯଦି ହେଲା, କେତେ ଟଙ୍କା ବାଇ ଜୁନ୍ 2026 ହବ?
75
6ଟା ଇନଷ୍ଟଲମେଣ୍ଟ ହେଲେ ବି still there is a due of around more than ଆପଣଙ୍କ 6ଟା ଇନଷ୍ଟଲମେଣ୍ଟ ସରିଗଲାଣି actually. ଆପଣଙ୍କର ଆପଣ ଯୋଉ ସୁପ୍ରିମ କୋର୍ଟ ହେଇଗଲେ ସେ ଷ୍ଟେ କରିଦେଲେ, ସେଟା ତ ହେଇନି
ନା।
ଆପଣ ଯଦି 10,000 ବି ଦେଇଥାନ୍ତେ ତାହେଲେ ଏବେ ଆପଣଙ୍କର ସେପଟେ ଅକ୍ଟୋବର ହେଲେ ନଭେମ୍ବର ଡିସେମ୍ବର ଏପଟେ 8 ମାସ ହେଇଗଲାଣି। ଆପଣ 8 ମାସ ପରେ ଦଉଛନ୍ତି, କହୁଛନ୍ତି 6ଟା ଇନଷ୍ଟଲମେଣ୍ଟ ମାଗୁଛନ୍ତି। Understand. So that I have been struggling to explain you that how my order will be illogical. ଆପଣ ଦେଲେନି ତାହେଲେ, ଆପଣ ଯୋଉ 6ଟା ଇନଷ୍ଟଲମେଣ୍ଟ 10,000 ଦେଲେନି କୋର୍ଟରେ, at least that could have saved the thing. Now we are in a situation after 8 months you are seeking 6 installments. Whereas the court, 4ଟା installment କେବେ ସରିଥାନ୍ତା?
We are expecting that it will be decreased. That is why.
Sorry?
We are expecting that the amount will be little bit decreased there. This
decrease ହବନି, future ରେ ହବ। From date of judgment 5,000 କେବେ ହେଲେ ବି କମିବନି। Don't make the submission and the order laughable. ଦିଟା ଲୋକଙ୍କ ପାଇଁ 5,000 ଟଙ୍କା High Court will interfere.
ଠିକ ଅଛି।
Take instruction. The petitioner shall file affidavit. कौन ता पर लिखने, sorry, sentence टा कौन था? Complaint. It is submitted by the Learned Counsel for the petitioner that the petitioner could could have satisfied the defaulted amount in 6 installments, which means that the petitioner would have been granted 6 months, which has already passed, and in fact 8 months have passed in the meantime. The petitioner shall file affidavit regarding deposit of the amount of arrears of rupees 60,000, as already 8 months have passed, though it was directed by the Lord Judge Family Court to be deposited within 4 months, and the petitioner himself 6 months to deposit the amount. The matter shall be listed for fresh admission in the week commencing
Odisha.
27. Yes, next. The amount shall be deposited before the allotted. The amount, the petitioner, if so decides, he shall deposit the amount before the allotted Judge Family Court, Noyagarh, to the credit of the to the credit of the judgment dated 30/10/2025, passed in serial MP number 41 of 2025. Yes, next.
12.
My lord, non-compliance of this honorable court, my lord, already, my lord, your lordship directed to take instruction.
No instruction has come yet.
Prior to this, my lord, already 2 times already your lordship's call for instruction, my lord. Still then, my lord, they have not supplied, my lord.
Yes, Mr. Bhanti.
Material
instruction has come.
appointment under RS scheme, my lord.
ବୁଝନ୍ତୁ ତାଙ୍କର ଆପଏଣ୍ଟମେଣ୍ଟ ହେଇଗଲେ ହେଲା ପ୍ରୋସେସ କରି କରନ୍ତୁ ଡାଇରେକ୍ସନ ଅଛି କନସିଡରେସନ ପାଇଁ ନା ଆପଏଣ୍ଟମେଣ୍ଟ ପାଇଁ
Appointment.
ଅଛି
Yes.
ତାପରେ କଣ ହେଲା ସୁପ୍ରିମ କୋର୍ଟ ଯାଇଥିଲା ନା କଣ
Supreme Court ଯାଇଥିଲେ ରିଟ୍ ଅପିଲ ହେଇଥିଲା ତାପରେ ସୁପ୍ରିମ କୋର୍ଟ ଯାଇକି
ଆମେଣ୍ଡେଡ ରୁଲ ଅନୁସାରେ କନସିଡରେସନ ହବ
yes
ବଟ ସେଟା ତ ଜଜମେଣ୍ଟ ନାହିଁ କଣ୍ଟେମ୍ପଟରି କେମିତି ହବ
but
ମାଇ ଲର୍ଡ ନା ବୁଝିବ ଆପଣ ବି ବୁଝିପାରୁନାହାନ୍ତି
no my lord on this list
ବଳାନନ୍ଦ ସେଠି ଇଜ ଇନ ଦ କଣ୍ଟେକ୍ସଟ ଅଫ ଦ अर्लियर
yes
ଆପଣ ପଢିବା ଅପେକ୍ଷା ଯାହା କହିବା କଥା ସବମିଟ କରନ୍ତୁ କ୍ୱେଶ୍ଚିନ
no by this list my lord my serial number was 51 my lord for consideration
କୋଉ ଲିଷ୍ଟ
এটা जो 2025 न्यू रूल्स रे कंसीडरेशन पे सेटा लिस्ट हेतिला
ଆପଣ ଟିକେ ଦେଖିବେ ଆପଣଙ୍କ ଅର୍ଡରଟା ନନ୍ କମ୍ପ୍ଲାଏନ୍ସ ର ଅର୍ଡରଟା
Yes.
ସେଟା 27/10/22 ର
यस
ଆପଣ ବର୍ତ୍ତମାନ ଲିଷ୍ଟ କରୁଛନ୍ତି 25 ର that is the precise question I am asking you ଆପଣ ଯଦି 27/10/22 ଟା ଇନସିଷ୍ଟ କରିବେ
यस मैम
ତାହେଲେ 25 ରେ କେମିତି କନସିଡରେସନ ହବ
27/10 पर तीन कंटेम्प्ट हेगल एटा मिसी
ହବ ତ ଫାର୍ଷ୍ଟ କଣ୍ଟେମ୍ପ୍ଟ ରେ ପନିଶମେଣ୍ଟ ନହେଲେ ଥାର୍ଡ କଣ୍ଟେମ୍ପ୍ଟ ହବ କଣ୍ଟେମ୍ପ୍ଟ ରେ ଫାର୍ଷ୍ଟ ରେ ପନିଶମେଣ୍ଟ ହବା କଥା
फास्ट
ଆପଣ
कंटेम्प्ट
କାହିଁକି ସେ ଅର୍ଡର ନଉଥିଲେ ନା ତଥାପି ବୁଝି ନାହାନ୍ତି
नहीं सी
ଆପଣ ଯୋଉଟା ଚାହୁଛନ୍ତି
ଏଟା ମାନେ that is-
ଅନୁସାରେ କନସିଡରେସନ
that is-
ହବ ଆଫ୍ଟର ଦ ସୁପ୍ରିମ କୋର୍ଟ ଡାଇରେକ୍ସନ
यस मैम
so how 22 will help you
मतलब दैट इज द ओरिजिनल ऑर्डर
ଅରିଜିନାଲ କି ଡୁପ୍ଲିକେଟ ପଚାରିଲେ କି ଆପଣଙ୍କୁ
यस मैम
ଯୋଉ ଆକ୍ଟ ଆପଣଙ୍କ 25 ରେ ଆସିଲା 22 ରେ କେମିତି ସେଟା ଇମ୍ପ୍ଲିମେଣ୍ଟ ହବ
मतलब ड्यू टू द पासिंग ऑफ दिस ऑर्डर इन ओरिजिनल केस मतलब दैट इज मतलब
25 ମସିହାରେ ଆକ୍ଟ ହେଲା ପୂର୍ବରୁ 22 ରେ ଅର୍ଡର ହେଇଗଲା
नो
ଆଜ୍ଞା,
नो नो 25 में से आगुर सेटा ऑर्डर रही
ବୁଝନ୍ତୁ ଆଜ୍ଞା 25 ମସିହା is a different thing
Yes.
this has already been explained
Yes.
several times ଆପଣ ମାନେ କି ବୁଝୁନାହାନ୍ତି
यस
ମିଷ୍ଟର ସିନ୍ହା ଯୋଉ ଆପଣଙ୍କର ସି ସେମିତି ଗୋଟେ ଦିନ ତାଙ୍କର ଚାଲିଲା
ओके
ତାର ଦିନେ ପରେ ସେ ତାପରେ ବୁଝି ପାରିଲେ if you want implementation of the 27/10/22 order
यस
you will not get the benefit of 25 act Bolagananda Sethi was not on the basis of 25 act
नो
କେତେ ସମୟ ଲାଗିଲା ମୁଁ ଆପଣଙ୍କୁ ବୁଝିବା ପାଇଁ
यस
so you are harming yourself
यस
by seeking implementation of the 27/10/22 order
but they have issued this notification on my lord 4/4/2025
ଦେଖନ୍ତୁ ସେଟା ଆସିଛି 4/4/25 ଟା was
Well,
not
that director was instructed from the secretary
ପ୍ରୋବ୍ଲେମ ହଉଛି କଣ କହିଲେ ଆପଣ ଯାହା ପଢିକି ଆସିଛନ୍ତି ସେଟା ବାରମ୍ବାର କହୁଛନ୍ତି
yes ma'am that is
4/4/25 ରେ ଯୋଉଟା ହେଇଛି ସେଟା ଅଛି is it a part of that writ petition
no ma'am
এইটা ବି ବୁଝିବା ପାଇଁ ଆପଣଙ୍କୁ ଲାଗିବ
Yes.
rather you should have done something else.
Let them pay.
Obviously, you are not achieving something by order dated 27/22 passed in WPC number because the 25 amendment was not there.
Yes.
No, neither you could have been considered also. 27/22 ରେ ଆପଣଙ୍କର ଥିଲେ ତ ଆପଣ କନସିଡର ହେବେ ନା
Yes.
ନ୍ୟୁ ରେଜିମ୍ ରେ ଆପଣ ଦେଖନ୍ତୁ ସେ ସୁପ୍ରିମ କୋର୍ଟ ଅର୍ଡରଟା ଅଛି ଜିତା ଲୁହା ଶହେ ଦୁଇଶହ କେସ୍ ଫାଇଲ କରୁଛନ୍ତି ଅର୍ଡର Supreme Court order. Supreme Court very clearly says, I think it is Jita Lua.
Yes, Jital.
Should mate apun assist kare padibo. Look at the operative portion of the Supreme Court's order.
Yes, ma'am.
In Jita Lua.
I have not brought my.
Nahi.
No, ma'am.
ठीक है, instruction never था. Mr. Mahanti, what he is saying, though it is in a content actually in merit cannot be discussed because there is a Supreme Court order that, but you have already prepared a list. से लिस्ट ऑफ कपड़े हम सर्व करना
Yes, ma'am.
सेटा मेमो रे दियंतु
Memo करते.
कोर्ट रे फाइल करंतु
Yes, ma'am. Today.
केबे करिवे आजि करिवे पासो
Yes, ma'am.
ना आउट दिनु कासियो
No, my lord. Just after lunch, I will.
ठीक है पासो कर सेटा फाइल करंतु so
Yes.
that we may obtain instruction on
Yes.
that सेटा
Yes.
हेले that is a clear strategy
Yes.
for legal strategy भी आपन को बुझिया पड़ियो ठीक है
13.
Petitioner Nanti, Mr. Paradis.
For the opposite party. Why?
Pass over kariba.
Aye.
Would you wait or adjourn it to another day?
No, it's pass over actually.
Please.
There's an interim order in favor of the petitioner.
This TRC series is transfer of what 498.
My lords. No, my lord, sir, that is a 120.
125.
120.
कॉल करिए देखिए पास over. ଯଦି ନ ଆସିବି ଦିଟା ବେଳେ ଆପଣ will have answer day. ଠିକ ଅଛି
14.
Item 14, may I please, Lordship?
yes please
Item 14,
Yes.
for fresh
Topic
addition,
correct for the petitioner opposite party black yes
this RPFM is filed. This is for fresh admission, Your Lordship, assailing the judgment dated 13/1/2026,
yes
where the opposite party wife of this case has been granted rupees 8,000 each. Not exactly her wife, the two daughters. One is 8 years old and another one is 4 years old. So the order which was passed was 8,000 rupees each. But Your Lordship will see this is a lot of things in this case, but in my service slip is there at page 34 of the brief.
look at the so what is the exhibit number before the trial court
So exhibit number, yes, sir. That is in the merit, Your Lordship. While presenting the case, I was supposed to, since it is for admission, Your Lordship, it is there. Copy of my salary statement of OP, copy of salary statement of OP of the year, this copy of birth certificate and Aadhaar card. Sir, it was
you are
my.
relying on what
I am relying on a development that is a
development
no,
cannot be taken note of
right, sir. Just I'm just trying to say on 13/1, this judgment was passed. But I, a retired army officer, I retired on 31/1 of the same month, which is this year. That is what I want to show in that slip, nothing
you
else.
have to file there
Yes, sir. So what happened
I'm
is,
not here to
correct, sir. Sir, what happened is that my earning is 26,000. That is what I want to say. That this is my merit.
26,000, that is a matter of evidence.
Sir,
and record.
26
If you want that
Yes, sir.
modification,
So move,
if you have Mr. Naik, you have stated before the trial court that your earning is 26,000.
Lords, that is my merit. See,
So you
that
show
part
that.
is
You show that here. If you have not shown, you have no case dismissed.
no,
Sir,
26,000.
I'm not sitting here to review. You can't re-argue.
No, I'm not re-arguing, Your Lordship.
So I'm showing you that out of the exhibits, which one you are relying on? There you are struggling.
I am relying on Your Lordship.
Page 30, which exhibit you are relying on?
So right now, in the judgment, the exhibit is at
Page 30 सीधा जान तो internal page 12, turning page 30.
Yes, sir. Page 30.
Which exhibit you are relying on?
Sir, I am relying on copy of salary statement of OP also.
Yes.
ତାଙ୍କର ହଉଛି 60,000 ମାନେ ମୋର ୱାଇଫ କର
ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ ହଉଛି କଣ ଆପଣ ଡେଟ୍ ଫେଟ୍ ଦେଖୁନାହାନ୍ତି
ସାର୍ ଆମର
ଆପଣଙ୍କର ପିଟିସନ କେବେ ଫାଇଲ ହେଲା
petition file which is after 13/1/2026 after the judgment was passed in February.
ପିଟିସନ ଟା ଫାଇଲ ହେଇଛି କଣ କହୁଛନ୍ତି
So petition is the
ଆପଣ ବି absent minded
the civil
the petition was filed before the trial court kebe
petition before the trial court. Yes, sir. So I have on 4/12/5/25.
so
12/5.
the court would have taken it no salary certificate of 26. You must keep the matters in seriety, in perspective.
Right.
Then that will be the best argument for you to place the facts.
Right.
The court could not have. ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ଯେ ଆପଣଙ୍କର pension has impacted. you
Pension
read the
has
judgment
impacted
of
us.
Supreme Court pension if you are saying that you have to take that plea
Because
that
they are
court,
taking
not this court.
because taking
Because the earning on the day the petition was filed has to be taken note of.
right.
That's enough. And what was the date of conclusion? The date of the
13/1.
the judgment was reserved.
Date of hearing, your lordship.
Yes. 5/1/2026.
Yes, sir. Date of argument is 5/1/2026.
The other problem is that ଆପଣଙ୍କର liability towards your daughter cannot be questioned.
Right, sir. Sir, it's not question.
So wife କର ନା ଆପଣ ତ your
Wife
ତ ସେ ଦେଇନାହାନ୍ତି
wife ହଉଛନ୍ତି 60,000 ମୋର ହଉଛି 26,000 ତା ଭିତରୁ 16,000 8,000 ଇଚ୍ କରିଦେଇଛନ୍ତି
ସେଟା କଣ କହୁଛନ୍ତି
ସାର୍ ଆମେ ଖାଲି ଟିକେ
ଆପଣ ଝିଅ ମାନଙ୍କୁ ଦେବେ ନା ନାହିଁ ସେଟା
ଆମେ ଦବାକୁ ରାଜି
ଦେବେନି ବୋଲି ତ
ଦେବି ନାଇଁ ସାର୍ ଦବୁ
Sir, ସେଥିରେ wife ଙ୍କର income ର କିଛି ରୋଲ ନାହିଁ
ନାଇଁ ସାର୍ ଆମେ ଦବାକୁ ରେଡି ଅଛୁ ସାର୍ ବଟ୍ 26 ରୁ 16 ନେଇ ଯାଉଛନ୍ତି ମୋ ପାଖରେ ଆଇ ଏମ୍ ରେଡି ଟୁ ଗିଭ୍
ଦେଖନ୍ତୁ
ଆମେ 4/4 ସାର୍ ଆପଣ 4/4 କି 5/5 କନସିଡର କରିବେ
ପୁରା ଆଣିବେ କମ୍ୟୁଟେଡ୍ କେତେ ଆପଣଙ୍କର କେତେ ପଇସା ନେଇଛନ୍ତି
ସାର୍ ମୁଁ ତାଙ୍କୁ ଗୋଟେ ଲ୍ୟାଣ୍ଡ ଦେଇଛି ଆଉ
ଫେରେ ଆରମ୍ଭ କରିଦେଲେ
ନାଇଁ ସାର୍ ମୁଁ ତାଙ୍କୁ
ଆପଣଙ୍କର ଯଦି ଫିଡିଂ ଅଛି ଲ୍ୟାଣ୍ଡ ଦେଇଛନ୍ତି ସେଥିରେ କଣ ଫାଇଣ୍ଡିଂ ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିବେ
ହଁ ସାର୍ ସେଇଟା ଦ୍ୟାଟ୍ ଇଜ देयर इन द
ଦେଇଛନ୍ତି ସେଟା ଅଲଗା କଥା ଆପଣ କହୁଛନ୍ତି ଯେ ଆପଣ ଯୋଉଟା ଆପଣ ଡିସଚାର୍ଜ ହେଇଛନ୍ତି
ଆଜ୍ଞା
ସେ ଯୋଉ ଡିଟେଲ୍ସ ଟା ସେଟା ଆପଣଙ୍କର ଦ୍ୟାଟ୍ ଇଜ February 2026 the petition is of January 2025 as you
right
are
sir
saying.
right sir
Then how it can be?
No, the question my lord is asking that whether I am willing to pay for my daughter. That is,
No, I'm
yes.
asking that. Because you are so confused, I'm assisting you. I'm not asking you. Because your problem is that you have started arguing the matter as if you are paying to the wife.
No,
I do not want
it
to
is for
pay
the
the daughters.
No, direct to the daughter.
So ଆପଣଙ୍କର
Sir,
the
considering
day the daughters filed maintenance, minor daughters filed maintenance, the court has to consider on that day what was your earning.
Sir, ଆମର
ଆପଣ ଯଦି ତାପରେ କମ୍ୟୁଟେଡ୍ ଭାବେ ନେଇଗଲେ ଆପଣ କମ୍ୟୁଟେଡ୍ କେତେ ଲକ୍ଷ ଟଙ୍କା ନେଇଛନ୍ତି That will be dismissed, Mr. Naik. You have no case.
There is a
because what you have done after 31st January 2026, you have filed those documents as if they were considered by the trial court, which the trial court could not have. It is now also in revision. Can I direct the trial court to consider
no new document can be
not only that, not only new, subsequent document, how the trial court will consider. ଆପଣ କଣ petition file କରିବେ?
My humble submission is ଟିକେ instruction ଟିକେ
କିଛି ନାହିଁ ଏଥିରେ ସେ stay କରିଦେଇଛନ୍ତି
କରିନା stay ଟା ମୁଁ ନାଇଁ stay ମୁଁ ଏଇଠିକି ଆଣିଛି ନା
ଏଠି stay ହେଇପାରିବନି
ନା ସୁପ୍ରିମ କୋର୍ଟ
ନିଜେ କରିବେ ନିଜେ
ସୁପ୍ରିମ କୋର୍ଟ sir I have not
I cannot pass an illegal order of stay.
No, I am not seeking for stay, lordship, only for some time for seeking instruction regarding the same and what amount I have deposited.
Amount କଣ?
Again, sir.
ଆପଣ ଟିକେ commuted pension ଟା ଦେଖନ୍ତୁ. He has also dished 34 ରେ
34.
ଦେଖନ୍ତୁ ବ୍ରେକଅପ୍ ଟା ଦେଖନ୍ତୁ.
Right, sir. 34 ରେ.
Service pension 24,000. Commuted service pension 11,549. TR amount 14,426.
This net amount
so
payable.
Net amount रे से आपको he has deceived you. The proposition is involuntary deduction. से बर्तन गोटे गाड़ी किनिले ଆପଣ କମ୍ୟୁଟେଡ୍ ଭ୍ୟାଲୁ 10 ଲକ୍ଷ ନେଇଗଲେ। କମ୍ୟୁଟେଡ୍ ଭ୍ୟାଲୁ ଯୋଉ 11,000 ଟଙ୍କା ସେଟା ବି ତାଙ୍କର ପିଲାମାନଙ୍କର ସେଟା ଅଛି। ଟୋଟାଲଟା ଦେଖନ୍ତୁ କି 24 ପ୍ଲସ୍ 14 ହେଲା କେତେ?
नहीं
38 ପ୍ଲସ୍ 11 50।
total net
ଇନଭଲେଣ୍ଟାରୀ ଡିଡକ୍ସନ ହଉଛି ଟ୍ୟାକ୍ସ। ଆପଣ ବର୍ତ୍ତମାନ ଗୋଟେ ବଡ ଫାର୍ମ ହାଉସ କଲେ ସିଏ
ମୋର
ଗୋଟେ ପଇସା ଖର୍ଚ୍ଚ କଲେ।
सर माय नेट पेएबल अमाउंट इज 37,750
ଆପଣ ସେଇଟା ନେଟ୍ ଟା ଆପଣଙ୍କ ଉପରେ ମୁଁ ଦେଖେଇଲି ଆଉ କଣ କିଛି ଏଣ୍ଟ୍ରି ନାହିଁ ନେଟ୍ ଛଡା।
मैं लास्ट
କମ୍ୟୁଟେଡ୍ is at your choice. Interestingly, the Supreme Court has dealt with such a situation.
yes sir let me find that let me find that your lordship at least bote gote argument kariar gote mauka diyantu sir mo gote
ଆପଣ argument ସାରି ଦେଲେଣି।
sir
Don't pretend that you have not been allowed to argue.
no I have sir
Because
sir this
on
verification
the face of it your arguments are improbable, so I'll record that.
this verification regarding Supreme Court sir mote gote khali mauka diyantu
नहीं,
kindly sir
ignorance of law is bliss.
no sir mo
For a
ignore
lawyer it is absolute bliss.
no ignore karbi sir wo
No, nothing. I'm not disputing, as you know, but
yes
whatever you are submitting, I'll record that. Because I'm not wasting time in sitting here.
right sir
And more so when the petitioner has tried to, deceptively deceive you. ସେ କମ୍ୟୁଟେଡ୍ ଭ୍ୟାଲୁ କଣ ଜାଣିଛନ୍ତି? 11,000 ଟଙ୍କା ସେ ଆଡଭାନ୍ସ ନେଇଥିବେ 10 ଲକ୍ଷ ଟଙ୍କା, ସେଥିପାଇଁ 11,000 ଟଙ୍କା କଟୁଛି। That he has to pay to the family.
sir I cannot
ଆପଣଙ୍କର ଟ୍ୟାକ୍ସ ନେଲେ,
ଆଜ୍ଞା
ଟ୍ୟାକ୍ସ ନଉଛନ୍ତି ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କି ଷ୍ଟେଟ୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଟ୍ୟାକ୍ସ ନେଲା, that obviously you have to.
but sir ତା ଭିତରୁ ହିଁ ମୁଁ 16,000
ଆମର ଆପଣ ନେଇଗଲେ ଆଗୁଆ ଟଙ୍କା, that is not an excuse. ଆପଣ ବୁଝି ପାରୁନାହାନ୍ତି।
my humble submission is
lack of preparation is apparent.
my humble submission is this but the purpose of this RPFM is to 16,000 to 8,000 ଟାକୁ କମ କରିବାକୁ।
ଆପଣ ବୁଝୁନାହାନ୍ତି
ତାହେଲେ ମୁଁ
ଆପଣ I'll record and reject it.
no
So I'll record it and reject
no my lord kindly
no petition reject करनी है।
no kindly your lordship will pass the necessary order any necessary
yes so Pratik Naik for the petitioner लिखिले
not any adverse remark your lordship
sorry
not any adverse remark your lordship
lawyer
not any adverse remark
against the lawyer I'm yet to do that
no
never I standing at the bar I have never commented on any lawyer much less as a judge I will do. I am not judging anyone. I am judging the case. Why should I make an adverse remark? But the difficulty is that upon say page रे खाली गोटिए कॉलम देखुछन आरोडा को देखु नांती।
the net payable amount 27
सेटा आपण कम्युटेड टा की देखिबो। You can't look the other way जदि काल नजर पड़ जो कम्युटेड वैल्यू रे कम्युटेड is part of your income. कम्युटेड जानछनी कोन?
also my lord
जानछनी कोन कम्युटेड वैल्यू? कोन?
ତାଙ୍କର he was in the army
କମ୍ୟୁଟେଡ୍ ଜାଣିଛନ୍ତି କି? ନା ସ୍ଟେଟ୍ ନାହିଁ କଲେ ମୁଁ କହିବି so that you can save time. କମ୍ୟୁଟେଡ୍ ହଉଛି ଯେ ଆପଣଙ୍କର ପେନସନ ଯଦି ପାଇବେ ଆପଣ 50,000 ଆପଣ ଆଡଭାନ୍ସ ନେଇଯିବେ 10 ଲକ୍ଷ 10 ଲକ୍ଷ ବାବଦରେ ଏଭଳି ମାସରେ ଆପଣ 11,000 ଟଙ୍କା ଦେବେ। Just giving a rough example.
right sir
So ଯେ ଯୋଉ 10 ଲକ୍ଷ ନେଇଥିଲେ ସେଥିରୁ ଆପଣ ତାଙ୍କୁ that is your part of your pension. adverse remark କେମିତି ହବ?
one last submission regarding this that at least we have submitted in the petition also
I have understood. You try to listen to the order, then if you find anything, then you tell. Don't. We are just simply wasting time.
mainly the wife's income is not taken into consideration. she be 60,000 जो पाउचंदी मु 26 रे
अच्छा सेटा सी आपन के अगेंस्ट क्लेम करछन आपन इते कंफ्यूज हे जाई छंती सेटा सेतोळ बुझौची when the daughter is claiming from the father the court cannot compel the wife to pay. The court will decide whether the father is liable to pay or not. Was it your plea in the written statement that the wife has to pay? I will not pay.
so the certified copy needs to be filed but सेटा मगे भी sir at the stage of admission
जो अपन ड्राफ्ट कला बेले आज माय एस्टीम सीनियर जस्टिस विश्वनाथ रथ always used to tell काहे देखिले नै एटा ड्राफ्ट कला बेले that's a serious mistake when you do not look at the pleadings and evidence. And in fact what Mr. Naik it is not that I have prepared separately. I am looking at the same documents what you have looked at. The petitioner before this court is the husband in the marriage. By filing the revision application, he challenges the judgment dated 13/1/2026 passed by the Lorded Judge Family Court, Jajpur, in criminal proceeding number 118/2025. The said criminal proceeding was initiated by the wife in the marriage and two minor daughters, aged about 8 years and 4 years, seeking monthly maintenance under section 125 of CRPC, 144 of BNSS. Stop. Before the trial court, the marriage between the petitioner and the opposite party number 1 was not an issue to be disputed. So also the birth of the two children, two daughters, was also not disputed. Perusal of the evidence of record before the Lorded Trial Court indicates that the petitioner examined herself as PW1 along with another independent person as PW2. The petitioner before the Lorded Trial Court, as wife in the marriage. The present petitioner examined himself as OPW1 and another witness as OPW2. Before the Learned Trial Court, the following exhibits were marked on behalf of the wife and the children. Page 30 copy of salary. The opposite party, present petitioner, did not mark any document as exhibit. The petitioner, the Learned Counsel for the petitioner has chosen to introduce a new document dated 31/1/2026, which is generated much after the judgment consideration by the Learned Trial Court and the judgment. Yes, he has annexed to the writ application the pension slip of February 2026, which indicates the following amount: service pension 24,875, commuted service pension 11,549, DR amount 14,425. The total amount coming to 24,875 যুক্ত 24,14,425 428 equal to 39,303. The recovery towards commuted service is 11,549. Now the petitioner takes a plea before this court that his net pension amount of pension is rupees 27,754. Therefore, the amount directed to be paid as maintenance to the two daughters is more than that could have been awarded. But the Learned Counsel for the petitioner is apprised of the judgment passed by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, wherein the Honorable Court have authoritatively dealt with the scope of power of revision to be exercised by this court. in when the order passed by the Lord Judge Family Court is under challenge. Paragraph 20. Apparently, the petitioner has voluntarily opted for commutation service element, which has led to reduction of rupees 11,549 every month from his pension. Therefore, such plea would be untenable to deny the maintenance to the daughters. Perusal of the judgment rendered by the Honorable by the Learned Judge Family Court indicates that the petitioner has not raised any plea in response to his salary statement of the year 2022 dated 12/2/22, based on which the Learned Judge Family Court has awarded amount of rupees 8,000 for each of the minor children. The Learned Judge Family Court has not awarded any amount of maintenance to the wife. Stop. At this stage, the Learned Counsel for the petitioner seeks for adjournment. Accordingly, the matter shall be listed for admission in the week commencing.
Anytime, my lord.
Tomorrow.
Any day.
Tomorrow.
One.
Yes.
1 week.
So why do you say any time? The week commencing 13/7. ସେ ଯେତେବେଳେ ଆପଣଙ୍କୁ ଦୁଃଖ ଭରି କାହାଣୀ କହିଲେ ଆଜ୍ଞା ମୋ ପାଖରେ ପଇସା ନାହିଁ ମୁଁ ବହୁତ ଅସୁବିଧାରେ ଅଛି ସେତେବେଳେ ଆପଣ ଆପଣଙ୍କର ଲିଗାଲ ନଲେଜ ଆଉ ଇଣ୍ଟୁଇସନ ତା ଭିତରେ ଭର୍ତ୍ତି କରିଥାନ୍ତି ଆପଣ ଭାବନ୍ତୁନି ଯେ ମୁଁ ଏଟା ଆପଣ ସାର୍ ପଢିଲିନି ସେ ଯୋଉ that salary that pension slip itself discloses what is the fact.
Right, sir. That is. I also want to discuss.
ଆପଣ କମ୍ୟୁଟେଟର ଗୋଟେ maximum limit ଅଛି ନହେଲେ ସେ ତ ଜିରୋ ବି କରିଦେବେ. And I didn't realize that Supreme Court has considered that in Samima Kharuki. That I give the paragraph there.
Right.
ଆପଣଙ୍କର it is only the involuntary ଆପଣଙ୍କର ତ ଯୋଉଟା compulsory exaction by the state ଅଛି କି କଣ ଅଛି ତାପରେ ଗୋଟେ ଲୋନ ନଉଛନ୍ତି ଆପଣଙ୍କର ବର୍ତ୍ତମାନ ସେ ଗୋଟେ ଲୋନ ନେବେ ଗାଡି କିଣିବେ ଆଜ୍ଞା ମୁଁ ଗାଡି ଲୋନ କିଣିଛି ଘର ଲୋନ କରିଛି ମୁଁ କାହିଁକି ଝିଅକୁ ମେଣ୍ଟେନ କରିବି possibly yes.
I am not allowed to present that, but that is also a fact of the matter.
But of course ସେଟା ଆପଣଙ୍କର ସେଟା ସେଠି ନବାର ଥିଲା.
Right, sir.
ଆପଣ ଟ୍ରାଏଲ କୋର୍ଟ ଦେଖୁନାହାନ୍ତି କରୁନାହାନ୍ତି ଯେମିତି ମାନେ ମିସଗାଇଡେଡ କେମିତି କରୁଛନ୍ତି ଗାଇଡ ଦେମ୍ ଇନ ଟ୍ରାଏଲ କୋର୍ଟ. Anyway, that is in a lighter vein. Rest of the matters after this is. See, asile apna Mr. Paradeep.
Grateful, my lord.
ठीक है. क्या कितना नंबर है? The murder to be not to be extended. Simply करो तो. Don't be that harsh. इनके तो वकीलों का था कि सुनो ना. And they are able to deceive like lawyers like the statute of Pratik. Like, see, jolly boy. You suggested date. Seta karo. You are Mr. Nanda or you are Patnaik.
On behalf of Rakshesh Darshan.
I'm sorry. Upon nada bully will watch. The lack of practice है ना. कितने चाहूँगी? 6 रे आगे अच्छी अपन करो 133. So we have the difficulty. अपन 13/7 रे नियम देखो. Entry order अच्छी कोच देते हैं. ठीक है तो till the next date of hearing. But I don't. Yes. MP करो तुम.
item 20 on behalf of item.
On behalf of sir recess for on behalf of. Then have a launch on behalf of. Sir.
Just now, he started a copy of the council file of
Agenda. Reply to the.
That's it. Appeal for opposite part of 4 and 5. However, likely it may not reach today.
Yes, sir.
Such a like my prayer is can it be taken up to come and think about 30.
13th or 20th, actually 13th, we are having 125. Because I am keeping track of how many matters total, urgent matters. On a 6th is 133, 13 is 125, 20th week re ଅଛି 113 ଟା. So 20 को add करा जाओ. 113 is a big number, still then it will be added to that. ତା ପୂର୍ବରୁ ହେଲେ 13 ରେ 125 ଟା ଅଛି. ଆଜି ଦେଖ add କରିଦେବି. 13 week ରେ 125 ଟା to be distributed. देखो 13. In fact, as I reach the for admission matter, I am not opening any further briefs because I want to complete. आगे. In fact, से affidavit कौन देले मुझे जाननी तापर.
I will be adopting the reply given earlier because there is nothing but repetition.
Right.
So I will not file any reply that only I have to make a statement that earlier affidavit filed by me has to be adopted for this.
Yes. Simply date कर देना होता. Simply without passing order date कर देना तो आप. Yes. 31-32 करंतु. We commencing 13/7. Right.
Some euros.
Yes.
Pleadings complete. A date check and a written note of submission.
Go more the same. और ये तो आर्गुमेंट करिवे स्ट्रो चीज आपण जोटा नै नथिबे प्ली प्रीडिंग्स रे सेटा रिटन नोट रे ऐड हे जिवो बेले बेले अदर साइड को से कॉपी विषय जानि भी नथिबे तो इट इज इम्पॉसिबल फॉर ए कोर्ट टू गेट आउट ऑफ द सिचुएशन तापर आपण अपील रे प्ली नेबे मु एगा रिटन नोट रे जोटा खिचली सेटा से कोर्ट कंसीडर करना देयर सो मेनी एस्पेक्ट्स दैट इज वन ऑफ द रीजंस दैट बेटर टू स्टिक टू द प्लीडिंग्स एनीवे आपण वीक डेट कर देले हां ठीक है
Achor item 12
को मेंशन करथिले
But item 21 on behalf of SK9 please email us kindly there is no item
अरे आपण तो देखु नाही दिस इज फॉर अपीयरेंस ऑफ द अपोजिट पार्टी आपण अपीयर कोन नाही अपोजिट पार्टी इतरे अदर साइड को नोटिस हला पर अपीयर करना है एक्सक्यूज कहउछंती त हां ताले नो काउंसिल एज अपीयर्ड काई नोटिंग आसीओ बार पांच ऑर्डरटा पढो हैला देह भलो हे बार पांच ऑर्डरटा पढो ना आपण मध्ये खराब हे गला कारण बार पांच रे आपण आर्गुमेंट करथिले हां से हबो से केस खराब हेले देह भी खराब हो
तो आमी क्या
ठीक अछि बट आई विल रिइटरेट दैट ऑर्डर केस खराब देह खराब जजिंग खराब होबा कथा न लॉ खराब होबा कथा आई कैन नॉट टेक द प्लीज देह खराब जज द देह खराब
first time as per the instruction the execution petition already filed and the petition already appeared and now
वो तो एग्जीक्यूटिव कोर्ट नो ना सबले रेलेवेंट सबमिशन करिवे वी आर बीइंग वाच्ड पण हठात जणे देखछन लॉ स्टूडेंट देखले जे जणे वकील आर्गुमेंट करने आरपीएफएम एग्जीक्यूशन हैज बीन फाइल्ड पिटिशनर हैज अपीयर्ड तार रेलेवेंस कोन अछि आपण सी थरा अपीयर कले 24/2 पर देह खराब सेटा ओडे तापरे एबे कोन करे जो कहले एबे हाई कोर्ट रे तो ऑटोमेटेड अछि टीएलसी और सीआरपी देखा जिवो टीएलसी अधिक अछि कि नै तापर जदी टीएलसी ठीक थिवो ताल सेटा लेखा जिवो दो देह खराब तो टीएलसी ठीक अछि नॉट दैट जजमेंट दिया आपण को देह खराब हेछि 12/5 रे मासे पर हे गेले दार पास देखो अपन पर मिस्टर एमआर पाड़ी एडवोकेट ऑन बिहाफ ऑफ एसके नायक दैट इज एडवांटेज ऑफ राइटिंग क्लियर ऑर्डर्स विथ अपीयरेंस ठीक है सेम मिस्टर एमआर पाड़ी से रहइबो यस Next.
Yes, ma'am.
Date ଆପଣ କରିଛନ୍ତି କି?
20 sir.
20.
That's our item 12.
That's the documents.
Mr. Ranjit Samal for the petitioner. The Lord Counsel for the petitioner submits that though earlier adjournment was sought for by on behalf of the opposite party, Choko's affidavit, public compliance affidavit has not been filed. Hello. The Lord Counsel files memo of dates which states thus. Enclosed to the memo is the letter dated 12/11/2025 issued by the Deputy Director so and so देखिए लिखिए, as well as the proceedings of the legal review meeting held on 16/1/2026 under the chairmanship of chairpersonship of the Commissioner cum Secretary, Department of Higher Education, Department of Co-Education. Department of Higher Education. It is higher than co-education.
Yes, school and math.
Department of School and Math Education.
Yes, ma'am.
Hello. ଆପଣଙ୍କ ନାଁଟା କୋଉ ସିରିଏଲରେ ଅଛି?
My lord, that is 11/8/2025. 28 serial.
Stop. The memo also enclosed to the memo is the letter dated, office letter dated 11/8/2025 issued by the Director Elementary Education, which the Commissioner cum Secretary, School and Mass Education. Serial number ଆପଣ କୋଉଥିରେ ଅଛି?
28. 28 and thereafter 51. Another letter.
Wherein the petitioner's name finds place at serial number 28. So, it is submitted by the Lord Counsel for the petitioner, referring to the aforesaid documents, that the petitioner's case is to be considered in terms of the amendment. सेटा 31/3/2025 ना 28 केते सेटा, in terms of the Odisha Rehabilitation Assistance
4/4/2025 not weeks.
with effect from केते?
This is 4/4/2025.
In terms of the amended provisions of so and so Odisha Rehabilitation Assistance rules, as amended on 4/4 amended by notification dated 4/4/2025.
Yes.
The Lord Additional Standing Council shall also obtain instruction in response to the memo filed by the Lord Counsel for the petitioner, as well as the contentions raised. Stop. Matter shall be listed in the week commencing.
Sorted.
It is positive. Supreme Court रे ହେଇଛି ଗୋଟେ positive हो.
Another letter may be mentioned, my lord. 23
छोड़ा এটা মেমোটা পুরা ମୁଁ କେତେ
23/25 ଗୋଟେ letter ଟା ଥିଲା.
ଖାଲି reproduce କରିଥିଲି to make my order comprehensive. Yes. 27 listed for orders. Yes.
Item 13.
Mr. Rajiv Lochan Patnaik for the petitioner, Mr. Muhammad Faratis for the opposite party, Mr. Dakshesh Darshan D. Naik on behalf of Rajiv Lochan, no, Dakshesh Darshan Naik on behalf of Rajiv Lochan Patnaik. Adjournment is sought for on behalf of the petitioner, the learned counsel for the opposite party has objection to the prayer of adjournment. However, taking a lenient view, the matter is adjourned to be listed in the week commencing 13/7/2026. Interim order dated so and so shall continue till the next day.
15.
Yes.
For transfer of a civil proceeding during number 239/2026 from Learned Judge Family Court of Balesur to Learned Judge Family Court Bhadrak, my lord, due to the present prisoner residing is old age parents and depend upon the parents, my lord.
Parents old age gale jurisdiction बदल जो एटा को provision रे अछि.
There is no male member to assist. And another thing, my lord, the present
एटा गोटे सरुआ कथा पर आंदर को जिबे. Male member नथिबे आ parents old age जिबे. को provision रे सेटा transfer jurisdiction transfer रे. कोथरे jurisdiction अछि आपण. Have you marked jurisdiction in CPC and Family Courts Act, Hindu Marriage Act?
no male.
Any proviso in case of absence of male member? आपण केटा केस करछन हस्बैंड को नारे. केतेटा? How many cases you have initiated against the husband? Under which provision? बहुत ही एक केस. कहवा को भी हमको जो
8-10 फाइल करछे.
8-10 तो? Yeah.
Another thing, my lord,
The
petition file, my lord.
petitioner wife in the marriage is before this court seeking transfer of the
Another distance, my lord. Distance होची 140 kilometers from the.
और सेड जानना नहीं सेटा कोठु कोन आपण यार सुड आपण सेपट आपण एपट एरिया लोक ना.
नहीं.
भद्रक बालेश्वर डिस्टेंस जानछंती.
नहीं.
140 कोन कोठु.
140 kilometer. As per instruction, my
इंस्ट्रक्शन ने कोन बॉडी जाने कोन ना. इंस्ट्रक्शन ने कोन बॉडी जो ना कोन डिस्टेंस ता फिक्स्ड.
नहीं से
आपण केतेटा केस वाइफ हस्बैंड ने 8-10टा करछंती जो. तो मेल मेंबर माने कोन मेल मेंबर ओल्ड एजिंग पेरेंट्स कोन असुविधा कले आपण को. किसी असुविधा ने आपण जतो केस करछंती. That cannot be.
Another thing, my lord, the present petition filed the CRP before the Learned Judge Family Court Bhadrak under section 125.
केबे फाइल कले.
हम फाइल करछि 2025.
तो सी तंगर फाइल करिवे सी तंगर डिफेंड करिवे. सी तंकर हस्बैंड तंगर डिफेंड करिवे कि हस्बैंड ट्रांसफर पे करिवे सेटा अलग कथा.
नहीं मु वाइफ फाइल करछि.
भलो करछंती. सेटा सेठी थाउ. बाकी 8टा केस कोन करछन. बा 9टा केस कोन हस्बैंड ने कोन केस को
नहीं केवल ए प्रेजेंट petition फाइल करछि गोटे 232 of 2025.
नहीं केतेटा समुदाय केस आपण केतेटा हस्बैंड को नारे करछन.
गोटे केस
498 डोमेस्टिक वायलेंस
ना आ किछ करनी ए 125 मेंटेनेंस टा करछि.
8-10टा कइले कोन केस करछन.
हम कहली मु करछि मु निजे सॉरी. जब तो प्रेजेंट
आपण वाइफ को 8-10टा केस करछन. हस्बैंड को नारे.
well myself sorry
myself आपण तो 100 संख्या रे करछन 8-10टा करछन.
the present petition file 125 be under section 144 BNS file कर maintenance before the Learned Judge Family Court Bhadrak Annexure 2 and another
हस्बैंड को केस फाइल करछन. को कोन
Annexure 1 टा divorce.
31
Annexure 1 टा divorce file 31.
The judge of behalf of the petitioner. Just. कितना नंबर आइटम 15 500
15 आज्ञा
Joydev Behra for the petitioner. The matter was passed over when the hard running counsel for the petitioner. The petitioner before this court is the wife in the marriage. She seeks transfer of the CP number 239 of 2026. Pending before the Learned Judge, Family Court, Balasore, to the Court of Learned Judge. Learned Judge, Family Court, Bhadrak. ଯେତେବେଳେ ନ୍ୟାସନାଲ ହାଇୱେ ଉପରେ ଯୋଉଟା ସିଟି ଅଛି ସେତେବେଳେ ଯୋଉ 140 250 ଏମିତି କହିବେ ଆଟ୍ ରାଣ୍ଡମ କହିବେନି ଆପଣ ଏଠି ବାହାରି ଗଲେ ସେଠି ଉପରେ ଲେଖା ହେଇଛି ବାଲେଶ୍ୱର ଇନଷ୍ଟ୍ରକ୍ସନ
ଆମ ଘରଠୁ ଏଇ ଯୋଉ ପ୍ରେଜେଣ୍ଟେସନ ଘରଠୁ ଇଏ ବାଲେଶ୍ୱର କୋର୍ଟଟା 140 କିଲୋମିଟର
କଟକରୁ ଭଦ୍ରକ କେତେ କିଲୋମିଟର? ଶହେ ଥିଲା 100 ଅଛି 100 ଥିଲା ଏବେ ଟିକେ ଯୋଉ ନୂଆ ଆଲାଇନମେଣ୍ଟ ହେଲା ପରେ 99 ନା 98 ହେଇଯାଇଛି 102-3 ଥିଲା so that is how what we were reading in mathematics in a linear ये यदि आपनकर गोटे डिस्टेंस फिक्स अछि ताले आपण ताको बढ़ाई परियोनी
नाही
जेडा 140 जदि 100 हबो आपनकर 140 हो बालेश्वर ताले कटकरू बालेश्वर हबो 240 बुझ परछन 100 प्लस 140 के 240 हो यस The CP has been filed by the husband in the marriage under section 13(1) of the Hindu Marriage Act, seeking dissolution of the marriage solemnized between the parties on 272020 and grant of decree of divorce. First wife कौन suspicious circumstances से मरी गले ना अपन हस्बैंड को नारे कौन आगुर दफा लागी ची
नाही सी एक्सपायर करा मारे
ठीक है नहीं माने एक्सपायर जो कली इट वाज ए नेचुरल और ए अननेचुरल होमिसाइडल डेथ
perhaps natural
okay yes it is submitted by the learned counsel for the petitioner that the wife is not maintained by the husband. The petitioner wife is not maintained by her husband. She has filed CRP number 232 of 2025 pending before the Learned Judge, Family Court, Bhadrak, seeking maintenance under section 125 of the 144 of the BNSS.
144.
It is submitted that after the marriage has run into rough weather, the petitioner stays with her parents at Bhadrak. कोट भद्रक रहउछन ना आपण आपन कटक रहउछन
हम घरटा पूरा इंटीरियर एरिया हम घर मो
अरे डिस्ट्रिक्ट भद्रक सर
डिस्ट्रिक्ट भद्रक
इंटीरियर को जगह हमरा
पुट्टसी बाग पोस्ट होची केसीपुर जलेश्वर पाक ना ना सॉरी जलेश्वर कहूची आ प्रेजेंट होची
भंडारी पोखरी मो बोले आपण को गोटे पर गोटे मिस्टेक करते
बहादुर नगर
आपण को बालेश्वर पाक जलेश्वरटा बालेश्वर को पाक
भंडारी पोखरी
माने आपण को बालेश्वर भद्रक को 140 जलेश्वर हेले आउरी 40
तरागो गोटे
भंडारी पोखरी तो
पोस्ट होची तरागो
भंडारी पोखरी at a village in the within the Bhandari Pokhari PS in the district of within the jurisdiction of Bhandari Pokhari PS in the district of Bhadrak. It is submitted that the petitioner finds it difficult to attend the case at Baleswar. Jaleshwar Baleswar ro uttar.
आज्ञा
आपण 140 से 40 मिसे की 180 कहले
नहीं हेला नहीं मु नेट रे जा देखि कि
नेट देखंतुनी
एआई तांगर बुझितिले आज्ञा
use NI use करूँ so that will help you. Finds it difficult to attend the case at Balasur. Stop. Issue notice along with this order. Issue notice the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 or 5, sir.
5 days.
Within 5 working days. Returnable date be fixed to 3/8/2026. The matter shall be listed in the week commencing 10/8/2026. IA. Had learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice to the opposite party as above. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed upon a prayer being made the CP number 8 pending before so and so shall be adjourned beyond a date. Adjourned to a date beyond the 17/8/2026 as would be convenient to the learned court in season of the matter. Urgent certified copy be issued as per. Yes.
16.
Your Lordship, I am appearing on behalf of learned Pratyusha Naidu, counsel.
Yes.
And she's not available to appear today because of the bereavement in her family. She went to Puri.
What is your
So
name?
I respectfully, Pratichi Jha. Pratichi Jha.
Pratichi
Jha.
Pratichi Jha. Ms. Pratichi Jha on behalf of Mr. Pratyusha Naidu for the petitioner, Mr. Anshuman Sethi for the opposite party. Adjournment is sought for in absence of the learned adjoining counsel for the petitioner. Mr. AC Uchanti 1227. 8 lakh. Press number. Adjournment is sought for on behalf of the learned in absence of the learned counsel for the petitioner due to personal difficulty. The matter shall be listed for fresh admission in the week commencing. 27/7. Ms. Jha? 27/7. Yes.
Much obliged.
So Mahanti, please. So Maheshwar Mahanti for the petitioner.
Here also, before starting the case, I have filed an IA for leave, grant of leave.
Not pressed gote thila seta mu bhuli goli IA 249 item 11 the margin lekhita mo ki dictation de bar phone
Rajesh.
Again Rajesh to te kah de 249 not pressed disposed the typographical error achi mention karthile. Yes, Mr. Mahanti.
Annexure 3 and 5 as the judgment and decree of the Coromandel Lok Adalat, my lord. And here, before passing a decree,
yes,
defendant number 1 died. He has not been substituted, decree has been passed.
But he did not be substituted, I think. Because there is a provision achi. You have to educate me that after completion of the proceeding, of the hearing, and when it is reserved for judgment, then any subsequent death of any of the parties will not impact the judgment and the decree. And on another aspect, the decree shall bear the sealed date of the judgment. That is also the point. Because actually, many times the decree is given a different date, but that is not contemplated in the CPC.
New amended CPC, decree is not important.
Yes.
Now, because the defendant 1 is dead, so his legal heirs, I have to file a leave petition to implement them. Because in the cause title, their names are not.
It could not have been. In fact, you can check that provision where it says that after it is reserved for judgment. So then it is not required.
My leave petition is to the extent that defendant 1 legal heirs are to be made parties in the present writ petition.
No, ultimately, sir, in the writ petition, what you are challenging?
I am challenging
the judgment and decree. On what grounds? Upon a substitution part, I got your point.
On the ground that the LTI given in the petition, judgment, decree, not attested. And the defendant 3 and other.
Not attested.
Not attested.
Correct.
And not read over and explained to the.
Correct.
And the Lawrence
so that the LTI is given by defendant or the plaintiff.
And their case that we have put our LTI.
Plaintiff or defendant? Who has put the LTI?
Well, I am defendant number 3.
Dependent 3.
3.
So you are saying that your LTI.
Not
given
only
on the
my
decree.
LTI, the LTI of other defendants have not been.
So was that plea taken before the trial court?
Sir, compromise जो ना file करते सही ना compromise है ना.
How about
Sir, plea या ना.
So that you see, it's a case of appearance, filing compromise decree, then dispute regarding the LTI. Can the court when it is filed, can the court go behind that?
The court is to give satisfaction that the LTI given by the parties.
Normal course rate. Because you are yourself filing the compromise decree. You are represented by the lawyer.
By the defendant.
In your presence, compromise decree is filed. This does not come under jealousy. Normally also, this is not applicable also.
Not applicable. Well, kindly see the satisfaction of the court under section 19 and 20 of the Legal Service Authority Act. The court is to make satisfaction.
19 and 20?
Like civil court. I have taken
that. So, CPC को जान दो सीधा.
Sir?
सीधा CPC रे जोटा provision अच्छी जोटा अपन साइड करूचोती. जे LTI रा जदी compromise decree file हबो. ताले LTI रे satisfaction नथिले compromise decree court entertain करिवेनी in presence of and appearance of the person who was given LTI. सेटा देखा. You are asking a wrong question. You will get a wrong answer. Question is what I have formulated. That you have to show. Mr. Mahanti, as you know, we make a lot of effort in achieving these compromises, especially in suits. Legal Service Authority Act कोठी अच्छे. CPC अच्छी. Transport CPC क्यों?
Sir, annex 3 times टिके मैं पढ़ी देवी.
पढ़ू ना आंटी?
आगे. Page 30.
तो मैसेज चले तो ना वो.
Sir, Annex 7 may.
Please, pardon.
The case record is put up before National Local Adalot for passing of order on a joint compromise petition filed by the plaintiff and defendants. They were all present on 24/23, being identified their respective counsel. They have filed their identity card and passport size photograph in support of their identity and filed joint compromise petition supported by affidavit. They also filed other forms and trace maps showing allotment of share among the parties having duly signed by the parties thereon. The contents of the compromise has been read over and explained to both parties to which they admitted. The parties put their LTI on the compromise petition. They submitted that it has been drafted as per their instruction. Peruse the case record.
So Mr. Mahanti, kindly stop there.
Aye.
So this is what I was asking you. The court has recorded its satisfaction that they have proved their LTI. They have been identified. Everything court has done. The problem is that I will be creating a dangerous precedent. In so many cases, sitting in Lok Adalat, I have passed orders on basis of LTI.
Aye.
They are present.
Aye.
Everything is done. They produce I-card, everything, LTI is there. And there is no provision. There is no provision in law in CPC that they have to put their LTI before the court. Because it is not meant for that also. So kindly read again. Each and every point the court has covered.
The parties put their LTI on compromise petition. They submit that it has been drafted as per their instruction. Peruse the case.
That's it.
Peruse the case record along with the contents of the compromise petition and the terms and conditions incorporated therein. It is found that this is a suit for partition.
It is Mr. Mahanti, this is a change of mood and perception. तांको कि बुझे जाला जे तमरो जो तमे काई राजी होउतिला तमे करम. This cannot be interfered with.
Sir, I'll shoot it. What is it? Well, the case along the content compromise petition and the term and condition incorporated therein. It is found that this is a suit for partition filed by the plaintiff against defendant. However, suit is amicably settled between the both parties. After considering fact and substance of the complaint petition, its related documents along with the case record, this court finds that Schedule B land of the plaintiff is the joint ancestral property of both parties. They entered in the complaint petition for partitioning the suit land in favor of the plaintiff and the defendants. Hence, complaint petition is allowed as per the term and condition mentioned by both the parties in their joint compromise petition. Suit of the plaintiff is declared finally in terms of compromise so far as it relates to parties to the suit and subject matter of suit, the compromise petition, trace map and Amin Badakam to part of the decree. It would be difficulty कौन है compromise petition है मैंने कोई दिले ये कौन पाइबो
ନାଇଁ ନାଇଁ
Plenty.
difficulty ଆପଣଙ୍କ major difficulty ହେଉଛି ଯୋଉଟାକ ଆପଣ ମାନେ just casually ପଢି ଦଉଛନ୍ତି ସେଟା ଆଉ ଥରେ ଗୋଟେ ପଢନ୍ତୁ page 37 ଟା ପଢନ୍ତୁ।
Sir, the case record is put up before National Lok Adalat for passing of order on a joint compromise.
They were all present on 24/11/23 being identified by their respective council.
Council. They have.
So that is the reason whenever a council appears, I say they do not appear. So how do you get over that?
ନା ଆମର ମୋର ହଉଛି 3ଟା ପଏଣ୍ଟ।
ଆପଣ 3ଟା ପଏଣ୍ଟ ରେ ଆଗ ଏଇ ପଏଣ୍ଟ ଗୁଡାକ ଓଭରକମ୍ କରନ୍ତୁ ତାପରେ 3ଟା ଆଡ୍ କରିବେ।
Sir,
So they were all present on 24/11/23 being identified by the respective council.
Judicial order I cannot deny.
No. You can deny, sir.
Sir.
You can deny. If I would have been a lawyer, I would have said that yes, I can deny, but under certain in a certain situation, very difficult. But what is your response in your this writ application? That I am asking you. You are saying that your LTI has not been identified, the contents have not been explained, read over and explained. So now you answer this. They were present on 24/11/23 being identified by the respective councils.
ନା ଇଂଲିଶ ରେ ଲେଖା ହେଲା allotment ଟା କି LTI ତାକୁ read over କି explain ହେଲା। Compromise petition annexure 2 series.
बिल्कुल उल्टाନ୍ତୁନି ମୁଁ 37 ବାହାରକୁ ଯିବିନି ଏତେ ସହଜରେ। 37 ର ଗୋଟେ ପରେ ଗୋଟେ
ଯାହା ପଚାରିବେ ମୁଁ ସେତିକି କହିବି।
ନାଇଁ 37 ର ଗୋଟେ ପରେ ଗୋଟେ ଆପଣ ଷ୍ଟ୍ରେଟ୍ ଆନ୍ସର ଦେବେ।
Sir,
ଆପଣ ପ୍ରେଜେଣ୍ଟ ଥିଲେ identified by your counsel on 24/11/23 have you denied that in your writ petition? ଯଦି କରିଛନ୍ତି କୋଉଠି କରିଛନ୍ତି ଦେଖନ୍ତୁ। ଏଇଟା ହେଲେ ଗୋଟେ ଆଡଭାଣ୍ଟେଜ ହେଉଛି କଣ କହିଲେ ମିଷ୍ଟର ମହାନ୍ତି? The standard advice is that don't look at the computer screen continuously. Look at a distant place, especially green. So that opportunity I am getting. Other than that, it is wastage of time. That was a blue ray not but still then continuously looking as a is always.
What I have developed.
ଆପଣଙ୍କର answer କଣ କହନ୍ତୁ?
My answer is
24/11/2023 ରେ so I'm sorry ଆପଣଙ୍କ stand what stand you have taken in the writ petition 24/11/23 ରେ ଆପଣ present ଥିଲେ
ଆମେ
you are identified
ଆମେ କହୁଛୁ ଆମେ କେବଳ LTI ଦେଇଛୁ ଆଉ ଆମେ
ସେଟା ତ କହିଛନ୍ତି ମୁଁ ବୁଝିଲି ସେଥିପାଇଁ ତ ପଚାରୁଛି ଆପଣ 24/11/23 ରେ ଆପଣଙ୍କ presence in court being identified by your lawyer what stand you have taken in the writ petition?
Sir, compromise petition ଦେଖନ୍ତୁ LTI ରେ କୋଉଠି ଆଇଡେଣ୍ଟିଫାଇ ହେଇଛି।
compromise ମୁଁ ପଚାରୁନି ଆପଣଙ୍କୁ ମୁଁ order କଥା ପଚାରୁଛି।
order ରେ ଲେଖା ହେଇଛି identified by
so you have not raised any point regarding that. ଆପଣ sir let me put the question in different way. ଆପଣ 24/11/23 ରେ present ଥିଲେ court ରେ identified by lawyer ସେଇଟାକୁ ଆପଣ writ petition ରେ କିଛି କହିଛନ୍ତି କିଛି କହିନାହାନ୍ତି ଠିକ ଅଛି। they have filed their identity cards and passport size photographs in support of their identity.
ସେଇଟା ବି ଆମେ
କିଛି କହିନା filed a joint compromise petition supported by affidavit.
ଆମେ କହୁଛୁ ସେଇଥିରେ ଆମେ କହିଛୁ ଆମଠୁ LTI ନିଆଯାଇଛି ଇଂଲିଶ ରେ compromise ଲେଖା ହେଲା ଆମେ ଟିପ ଦେଇଛୁ ଆମକୁ ପଢି ଶୁଣି ବୁଝେଇ ଦିଆ ହେଇନି କି ଆମକୁ ଆମ ଟିପ ବି attested ହେଇନି। ଏଟା ହଉଛି ସାର୍ଟିଫାଇଡ୍ କପି।
ଠିକ ଅଛି ତାପରେ ପଢନ୍ତୁ ତାପରେ 37 ରେ ପଢନ୍ତୁ concentrate on 37 supported by affidavit କିଛି କହିନାହାନ୍ତି
ନା। They also filed
ଆପଣଙ୍କର filing ଟା ଆପଣ dispute କରୁନାହାନ୍ତି
ନା।
They also filed Amin other firms
and trace
map showing allotment of shares among the parties having duly signed by the parties thereof.
Sir, ଏଇଠି ମୁଁ ଟିକେ defendant 3 ର other firm create ହେଇନି ସେଟା ଆଉ ଗୋଟେ peculiar compromise petition ଦିଆଗଲା କିନ୍ତୁ other
defendant 3 ର share କେତେ?
sir ତାଙ୍କ genuine ଅନୁସାରେ 1/3 sir ମୁଁ ଦେଖେଇ ଦଉ ତାଙ୍କ
1/3 ତାଙ୍କର predecessor in interest କେତେ ପାଇଛନ୍ତି?
sir ଆସନ୍ତୁ page 15
1/3 ଟା post type ହବ 1/3 ଟା ପରେ ହବ ତାଙ୍କର ଅନ୍ୟ ମାନେ ଯୋଉ 1/3
sir 4 ଜଣ
ମିଲେ ବୁଝି ପାରିବେ କହିଲେ ବୁଝି ପାରିବେନି I will explain
sir
it has some relevance. You may say that ସେ କଣ ୟାର ଛୋଟ ପଚାରୁଛନ୍ତି କି ଜାଣିନାହାନ୍ତି ସେଟା ଅଲଗା କଥା ଏଟା ବାହାରେ ଦେଖତ ବାଧ୍ୟ ହେଇକି ଆପଣ ଶୁଣିବାକୁ ପଡିବ ଯୋଉ 1/3 ପାଇଲେ ବାକି 2 ଜଣ କେତେ ପାଇଛନ୍ତି?
1/4 sir
ଆପଣଙ୍କ 1/4 ବାକି 3 ଜଣ କେତେ ପାଇଛନ୍ତି?
सर 1/4 ହେଲା ସମସ୍ତଙ୍କର 4 ଜଣଙ୍କର
4 ଜଣ
Defendant one, 1/4
ବାକି 3 ଜଣ ପାଇଛନ୍ତି ନା ନାହିଁ ପଚାରୁଛି ସେଇଟା ଆପଣ
सर compromise petition ଲେଖା ହେଲା
ବାକି 3 ଜଣ ପାଇଛନ୍ତି ନା ନାହିଁ
ପାଇଛନ୍ତି
ସରିଲା ତାହେଲେ
କିନ୍ତୁ
ଠିକ
सर
ଅଛି
सर ଟିକେ ଶୁଣନ୍ତୁ
ଶୁଣନ୍ତୁ ତାପରେ ନେକ୍ସଟ ମୁଁ ଆସିବି ଆପଣ
Sir.
37 ବାହାରକୁ ଗଲା ପରେ ଆପଣ ଆରମ୍ଭ
सर
କରିବେ।
ବଦର ଫର୍ମକୁ ଆସନ୍ତୁ
ନାଇଁ ବଦର ଫର୍ମ ବର୍ତ୍ତମାନ ଦରକାର ନାହିଁ କାରଣ ଆପଣ କହୁଛନ୍ତି ଯେ ବଦର ଫର୍ମରେ 4 ଜଣକୁ 3 ଜଣ ପାଇଛନ୍ତି ଆପଣ ପାଇନାହାନ୍ତି ଦ୍ୟାଟ୍ସ ଏ ସେପାରେଟ ଇସ୍ୟୁ ଅଲ୍ ଟୁଗେଦର
ଆଜ୍ଞା
ତାହେଲେ ଆପଣ ଯଦି ଗୋଟେ ସେୟାରରେ 1/4 ଜାଗାରେ ଆପଣ ପାଇଲେନି ବାକି 3/4 କଣ ହେଲା ମାନେ ଆପଣ ଗୋଟେ ଟିକେ କମ୍ପ୍ଲିକେଟେଡ ହେଇଯାଉଛି ଏଟା ଟିକେ ଧ୍ୟାନ ଦେଇ ଶୁଣିବେ
ଆଜ୍ଞା
ଯଦି ଗୋଟେ ସେୟାର 4 ଭାଗ ହବ ଜଣେ କେତେ ଭାଗ ପାଇବେ ଯୋଉଟା ଚାରଣା କହନ୍ତି ଚାରଣା କିସ୍ମତ କୁହାଯାଉଛି ଓଡିଆରେ 1/4 3 ଭାଗ ହେଲେ କେତେ ପାଇବେ
75
75 ରୁ 33 ପାଇବେ
3 ଭାଗ ହେଲେ 33
ସୋ ଆପଣ ଯଦି ପାଇନଥାନ୍ତେ ଅନ୍ୟମାନେ କେତେ ପାଇଥାନ୍ତେ
ଅନ୍ୟମାନେ ପାଇଥାନ୍ତି 33 ନା
33 ଆପଣ କିନ୍ତୁ ଅନ୍ୟମାନେ 1/4 ଚାରଣା କେମିତି ପାଇବେ ସୋ ଦ୍ୟାଟ୍ ଆନ୍ସର୍ସ ୟେସ୍ ନେକ୍ସଟ ସେ ଆପଣ କହୁଛନ୍ତି ଯେ ଦେ ଅଲସୋ ଫାଇଲ୍ଡ ଅମିନ ବଦର ଫର୍ମ ଆପଣଙ୍କର ଅମିନ ବଦର ଫର୍ମ ଫାଇଲ୍ ହେଇନି
ଫାଇଲ୍
अच्छा ड्यूली साइंड बाय द पार्टीज देयर आपण सिग्नेचर माने एलटीआई अछि
हमर एलटीआई
एलटीआई
कोठे मते एक्सप्लेन कराई
आपण तो एलटीआई अछि से तो सरला
नहीं
तो से पार्ट आपणकर अरे सी जो साइन कहउचंदी आपण माने समस्त तो टिप मारिचंदी तो सेतिरे से साइन माने से ही मीन करछन
आगे
से होते आपण कहउचंदी लिखि थाते एलटीआई इंक्लूडिंग साइड सिग्नेचर इंक्लूडिंग एलटीआई
आगे
आपणकर सेही पेज रे ही 4टा एलटीआई अछि
एलटीआई इंडिविजुअल एलटीआई शुड बी अटेस्टेड
वकील करछन तो अनुनांती बोधे
इंडिविजुअल एलटीआई अटेस्टेड हेनी सर देखुन
पेज 37 देखो
पेज 18 सर आसुन
37 देखो
मु कंपनी पिटिशन कहूची 37 भी आसुन
37 बाहर सबडे उल्टे मु पर जीवित मना कली
सर
देखो सबुतर एडवोकेट साइन करछन
सर काई सर पेज 37 सर
सबुतर एडवोकेट साइन करछन
सर
इंडिविजुअल
ये एलटीआई रे के अटेस्ट करना
सबु आगे सबुतर
सर हेमा माली
आपण गोटे सिंपल काम करंतु एलटीआई केटा दस्खत केटा गणी दियंतु
सर एलटीआई 1 2 3 4
हां
पेज
सब चारिटा अछि
10 अछि सर दीटा
चारिटा
पेज 37 सर
हां देखो मते देखंतुनी मो पाखर सब अछि
सर एलटीआई ऑफ रुइहा माझी
हां
अटेस्टेड
सब अछि
एलटीआई ऑफ हेमा माझी नॉट अटेस्टेड
नै अटेस्टेड
ना हेन सर
केते नंबरटा सेटा आपण जदी ऊपुरु जिबे
हां
डाहण पटे चारटा अछि सेकंडटा हिची आगे
सेकंड और थर्ड
आपनकर प्रॉब्लम कोन हिची कहले फास्ट टा कोनांतु चारटा अछि सेपे कहले चारटा गणंतु बोली
हां 1 2 3 4
हां चारटा एलटीआई चारटा अटेस्टेशन सेतिर आपण कंफ्यूजन हिची जदी बा नहले आपण सेटा की यूटिलाइज करते बिकॉज़ आई नो यू आर ए सीजन्ड एंड वन ऑफ द स्मार्टेस्ट लॉयर्स
सर मु सर्टिफिकेट
सुनो आपण मो पर सर्टिफिकेट कॉपी अछि
मु
कुछ अलग कॉपी देखुनी
सर
तळु देखिले तळे जो अटेस्टेशन ता तारो ता परे अछि सेकंड रो ता परे अछि थर्ड रो ता परे अछि फोर्थ रो ता परे अछि सो सबुडा अटेस्टेड हिची अगे जी सिटी बसचंती सिविल जज सीनियर डिवीजन की अगे दे आर सीजन्ड कैंपेनर
37
जे आंबळा रीड रे बसथांते से माने मिस करिवे जजमेंट रे आगे चारटा जाक अछि
सर के हम फाइल
देखु ना स्क्रीन में देखम सर
से फाइल
नहीं स्क्रीन टा देखो ना मु देखु जे आपण देखिबे अगे सेटा वर्षन पेपरलेस रे आपण देखिया पड़ियो या नो गोइंग बैक ठीक है सर को काढी दंतु पेज 37 मिस्टर सुबह पेज 37 देखो राइट हैंड मार्जिन रे चारटा अछि दस्खत इनफैक्ट से एडवोकेट भी साइन मारछनी तीनटा हेइथिले आपण जोडा क्वेश्चन ठीक हेइथा
सर मु देखो
मार्जिन रे देखंतु चारिटा अछि ठीक एलटीआई चारटा दस्खत हेइची आपण कोन देखिले आपण व्हाट यू आर सेइंग
सर मु पढु छै
हां
आपण एलटीआई जो मानकर तक ना लिखा ऊपर ना लिखा है अटेस्टेड है सेकंड ता ना लिखा है अटेस्टेड है
नहीं हिच शुणु आपणकर कहवा कथा जे जो ये सेटा जो माने सेटा आपणकर से
चारिटा अटेस्टेशन नाही सर दुईटा अटेस्टेशन अछि आ दुईटा रे अटेस्टेशन नाही सिंगल
आपणकर एडवोकेट देखु सम की कोटे कोन के दस्खत करिछन
नाही अटेस्टेशन
anyway let us leave it there आपण कहउछन नाही बोली ठीक है
सिमिलर डिफिकल्टी आछि कंपनी पिटिशन
let us come back to 37
अच्छा 37 sir 39 data attestation
ନାଇଁ ନାଇଁ attestation ଚାରିଟା ଅଛି ଛାଡ଼
sir data sir ମୁଁ detail
ଆଜ୍ଞା ଶୁଣନ୍ତୁ ସେ ଯୋଉ ଆପଣ କହୁଛନ୍ତି ଯିଏ ଲେଖିଲେ LTI so and so ସେ କ'ଣ କରୁଥିଲେ? Have you examined it? I will call him and examine him here. Then will be in real trouble. I will impose heavy cost. ଯିଏ LTI ଶୁଣନ୍ତୁ ଯିଏ ସେଠି ବସିଛନ୍ତି ଜୁଡିସିଆଲ ଅଫିସର ସେ ଆଜ୍ଞା ନୁହନ୍ତି ଆପଣ ଭାବିବେ ଯେ ସେ ତ ଖାଲି ରିଡ୍ କରୁଥିଲେ ଜାଣିନାହାନ୍ତି ସେ ବି ଆଜ୍ଞା ଜଣେ ଜଜ୍ ତାଙ୍କୁ ଏତେ ହାଲକାରେ ନେଇ ହବ ତାପରେ ପଢନ୍ତୁ କମ୍ ବ୍ୟାକ୍ ଟୁ 37
they also filed
Yeah, having duly said that the contents of the compromise petition has been read over and explained to both the parties to which they admitted.
ଆଜ୍ଞା
ତାର କ'ଣ stand ନେଇଛନ୍ତି ଆପଣ ରିଟ୍ ପିଟିସନ
ଆମେ କହିଛୁ ଆମେ LTI ଆମେ ତ ଇଂଲିଶ କିଛି ବୁଝିନୁ
read over and explained ଇଂଲିଶ ତ ଆପଣ କି ବୁଝିବେ ପଚାରୁଛନ୍ତି
ନା ନା ରେଡ୍ ଓଭର ଏକ୍ସପ୍ଲେନ୍ ହେଇନି
ଆପଣ ଯଦି stand ନେଇଛନ୍ତି ଯେ ଇଂଲିଶରେ କହିଲେ ବୋଲି
ନା ନା ରେଡ୍ ଓଭର
ନାଇଁ ନା କରନ୍ତୁନି ହଁ କରନ୍ତୁ ଆପଣଙ୍କୁ ଇଂଲିଶରେ କହିଛନ୍ତି ବୋଲି କୋଉଠି କହିଛନ୍ତି କି
ଇଂଲିଶରେ କମ୍ପ୍ରୋମାଇଜ ଲେଖା ହେଇଛି
read over and explained
ସାର୍ ଜୁଡିସିଆଲ ଅର୍ଡର ଦେଖିଲେ ତ ମୁଁ କିଛି କହିପାରିବିନି
ଛାଡ଼ ମୋ କେସ୍
ସାର୍ ଟିକେ ମୁଁ
ସେଇଟା କଣ ଗୋଳାନ୍ତୁ
ନା ମୁଁ ସେଇଟା ବୋଲୁନି ମୋର
ତାପରେ ଦେଖନ୍ତୁ the parties put their LTIs on the compromise petition এটা কোর্ট রে ହେଇଛି
ଆଜ୍ଞା
এটা past tense ନୁହଁ
ଆଜ୍ଞା
they submitted that it has been drafted as per their instruction ତାର କ'ଣ stand ନେଇଛନ୍ତି ଆପଣ unless you take a stand I give a finding on that I cannot interfere
ଆଜ୍ଞା ମୋର ଆଉ ଦିଟା ଗ୍ରାଉଣ୍ଡ ଖାଲି କହୁଛି
ହଁ କୁହନ୍ତୁ ସେଟା ଆପଣଙ୍କର ଜୁଡିସିଆଲ ଅର୍ଡର ରେ ଯୋଉଟା ଅଛି ଆପଣ କ'ଣ stand ନେଇଛନ୍ତି that you have now completed next round ହେଲେ
ସାର୍ ମୋର ଗ୍ରାଉଣ୍ଡ ହେଲା ମୋର ଗ୍ରାଉଣ୍ଡ ହେଲା ଅର୍ଡର 23 ରୁଲ୍ 3 ଯୋଉଟା CPC ରେ ଯୋଉ ସାଟିସ୍ଫାକ୍ସନ ଦରକାର ଅର୍ଡର 23 ରୁଲ୍ 3 CPC ଅନୁସାରେ ଯୋଉ କମ୍ପ୍ରୋମାଇଜ ଆସେପ୍ଟ ହୁଏ
ସେଟା ଦେଖିବେ ଆଗ ଲିଗାଲ ସର୍ଭିସ ଅଥରିଟି ଆକ୍ଟ ରେ ଅଛି ସେଟା ଆଗ ଦେଖିବେ କୁଆଡ଼େ ଗଲା ଆଣିନାହାନ୍ତି ବହି ଠିକ ଅଛି କ'ଣ CPC ର କୋଉଟା କହୁଛନ୍ତି
ମୁଁ କହୁଛି ଅର୍ଡର 23 ରୁଲ୍ 3 ତାର ଗୋଟେ ସାଟିସ୍ଫାକ୍ସନ ଅଫ ଦି କୋର୍ଟ ଅଛି
CPC ରେ ଦିଅନ୍ତୁ ଆପଣଙ୍କର ସେଇଟାରେ ହିଁ ଆପଣଙ୍କୁ ପଚରା ହଉଥିଲା
ଆଜ୍ଞା
ଆଠୁ କୌଣସି ଅଧିକା କୋର୍ଟ ଏଇ ଯୋଉ 10ଟା ପଏଣ୍ଟ ସେ 7-8ଟା ସାର୍ଙ୍କୁ ଦେବେ ସେଇଟା
Policy Order 23 Rule 3 compromise of suit where it is proved with the satisfaction of the court that the suit has been adjusted wholly
এটা সুট নয় এটা আপনার আগে লিগাল সর্ভিস অথরিটি আগে লোক আদালতের আগে যান
ঠিক আছে স্যার সেকশন 20 के our validity of so going by the terms
আগে দেখিবে applicability of CPC
नेक्स्ट वीक रो मु applicability टा ठीक देखि
ମୁଁ ଏବେ ଦେଖି ମୁଁ ଆଉ ସମୟ ନଷ୍ଟ କରିପାରିବିନି
सर नेक्स्ट वीक रो सर
ନାଇଁ ମୁଁ ଆପଣ ଆଡଜଷ୍ଟମେଣ୍ଟ ଦେଇଦେବି ଗୋଟେ ରେକର୍ଡ ହ୍ୱାଟ
सर applicability
ଆଜିକାଲି ଡିସ୍କସନ ମୁଁ ଆଜ୍ଞା ଆମେ ଅଧଘଣ୍ଟା କଲେ ଗୋଟେ ପଏଣ୍ଟ ରେ
सर मु ସେଇଟା ଟିକେ ଦେଖିନି ମୁଁ ମାନି ଯାଉଛି
ଆପଣ CPC ସେଟ୍ କରିବାର ନଥିଲା
ନା CPC
ଆପଣ CPC ଆପଣ compromise in a suit is different and look adalat award is different
satisfaction
that is a clear distinction interestingly the court being a civil court has followed order 23 rule 3 ନହେଲେ 8ଟା ପଏଣ୍ଟ ସେ ଲେଖି ନଥାନ୍ତେ।
Next week sir
ନାଇଁ ରହିବ ନେକ୍ସଟ ୱିକ୍ ଠିକ ଅଛି।
sir.
ମୋର 20 ଅଛି।
Sir.
ଓକେ ଏଲଏସଏ ଆକ୍ଟ ଟା ଧରିଛନ୍ତି
Sir.
ଦେଖନ୍ତୁ 20 19(5) ଦେଖନ୍ତୁ।
Sir, in any case refer to clause 1 of section
19(5) ହଉଛି a local adalat shall have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of any case pending before or any matter which is falling within the jurisdiction of and is not brought before any court for which the local adalat is organized. ହେଲା ତାପରେ ଦେଖିବେ 20 wherein any case referred to in clause 1 subsection 5 of section 19 ସେଟା ମୁଁ ପଢିଲେ one of the parties thereof and makes an application to the court for referring the case to the local adalat for settlement, and if such court is prima facie satisfied that there are chances of such settlement or the court is satisfied that the matter is an appropriate one to be taken cognizance by the local adalat, the court shall refer the case to the local adalat. ଏଠି କୋର୍ଟ କିଏ ଲୋକ ଅଦାଲତ କିଏ? କୋର୍ଟ ହଉଛି ଅରିଜିନାଲ କୋର୍ଟ ଯୋଉଟା ଆପଣ ସିପିସି
civil judge senior division
ହଁ ସେଇଟା ଏଠି ଲୋକ ଅଦାଲତ ହଉଛି ଆଉ ଗୋଟେ କୋର୍ଟ। In fact the legal services authority act makes a distinction between a court and a local adalat. So this is different. That is how they have said that these principles should not apply in case of local adalat. Then it is more than a suit.
My entire agreement is ଗୋଟେ opportunity ମତେ ଦେଇଥାନ୍ତେ।
ଅପରଚୁନିଟି ପାଇଁ ଦିଆ ହେଇଛି ଆଜ୍ଞା, ଅଧିକ ଅପରଚୁନିଟି ଦିଆ ହେଇଛି।
ଆଚ୍ଛା ଥାଉ ନେକ୍ସଟ
The petitioner is before this court challenging the award of the Lok Adalat dated out of the Lok Adalat by final decree dated 19/12/2023 in CS number 657 of 2023. In the National Lok Adalat by the Honorable Civil Judge, Senior Division Baripada. The said final decree was awarded or made pursuant to the compromise petition filed by the parties and the matter being referred to the Lok Adalat. Stop.
Annexure 3 ରେ ଆଗ ଜଜମେଣ୍ଟ ହେଲା ତାପରେ ଡିଫାଇନାଲ।
The judgment was rendered by the Lok Adalat by order dated the
order written
the Lok Adalat before the Lok Adalat, that is Civil Judge Senior Division, Senior Civil Judge Baripada. The suit was CS number 657 of 2023 was concluded by order number 7 dated 9/12/2023. It is it is submitted by the learned counsel for the petitioner that the award of the Lok Adalat, the consequential decree and the disposal of the civil suit is challenged on the grounds that the LTI of the present petitioner, who was the defendant number 3 before the learned court, has not been attested. The present petitioner defendant was not aware of the compromise decree. The decree being compromise petition, the petition being in English. एटा तो प्रिंसिपल ग्राउंड ना कोन रहला एटी अटेस्टेशन हेनी आपनकर compromise decree अपन जान ना
फाइनल डिग्री पूर्वरु जणे
आपनकर third point भूली गेले the further argument of the learned counsel for the petitioner is that the Amin Badar firm
डिफेंडेंट वन टा मरि गला आफ्टर जजमेंट बिफोर डिग्री तो डिग्री रे मला लोक ना डिग्री हेला
हबो तो जीवंत लोक केमती होबा रादर जदि जीवंत लोक रे करथांते आपण चैलेंज करथांते हु वाज नॉट अ डिफेंडेंट बिफोर द ट्रायल कोर्ट सेटा आपण से जो प्रोविजन टा अछि देखंतु सेटा
ना हमर ग्राउंड
सब्स्टिट्यूशन ग्राउंड टा जेबे जोटा लीगल ग्राउंड ले हबो ना सब्स्टिट्यूशन काहे कि सीपीसी परमिट करूनी because after conclusion of the trial and reserved for judgment, if it is somebody passes away, it can't be reopened. ये जदि चाहिए ताका लीगल है सी ताका रो चैलेंज करि पारंती बट दे विल सीक लीव जे सी ताका नारे डिग्री हेतला सी चली गले हमें ताका लीगल है हमु चामे से अपील रे करी
जेहेतु कॉज टाइटल ले ताका ना अछि डिसीज ना त मु लीव पिटिशन टा फाइल कर
सेटा आपण वर्तमान पे कहू एटा आपनकर केस ना
आगे
the Amin Badar firm towards the share of the defendant number 3 was not presented before the civil court. Civil court, that is Lok Adalat. Before the Lok Adalat kar diyo. Lok Adalat, not civil court, Lok Adalat. Para. In order to consider the submissions of the learned counsel for the petitioner, this court has gone through the judgment passed by the learned Lok Adalat. Judgment passed in the National Lok Adalat by the learned Civil Judge Senior Division Baripada, which states thus. Which records thus. Page 37, this case record is put up before National Lok Adalat to neki Sesa Pajan, filing of stamp paper. Regarding the LTI, it is evident from the LTI not being attested. ଆପଣଙ୍କର ଓକିଲ ଅଲଗା ଥିଲେ ନା ଏକା ଥିଲେ ଆପଣ ଯେତେବେଳେ ପଚାରିଲି ଗୋଟେ ଜିନିଷ ଆପଣ ସେତେବେଳେ ବୁଝିଯିବା କଥା ସେ ସେଥିପାଇଁ ସାଇନ୍ କରିନାହାନ୍ତି ଯେତେବେଳେ when he is holding वकालतनामा for all the defendants he could not have signed every time ଆପଣ ଯେତେବେଳେ वकालतनामा फाइल କରୁଛନ୍ତି କଣ ଡାହାଣ ପଟେ ବାଁ ପଟେ ଗୋଟେ ସିଗ୍ନେଚର ଡାହାଣ ପଟେ ଯେ ଜଣ ଏକ୍ଜିକ୍ୟୁଟେଣ୍ଟ ସମସ୍ତଙ୍କ ସିଗ୍ନେଚର ଆପଣ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ କଲେଣି ବର୍ତ୍ତମାନ ଯେତେଟା ହେବେ ଯେତେଟା ଡିପେଣ୍ଡେଣ୍ଟ ସେତେଟା ସିଗ୍ନେଚର
एविडेंस एक्ट कहला प्रति एलटीआई पे अटेस्टेड
ଆଜ୍ଞା ପ୍ରତି ଏଲଟି ପାଇଁ ଆଟେଷ୍ଟେଡ ସେ କରିଛନ୍ତି ଟେକ୍ନିକାଲି ଆପଣ ଯୋଉଟା କହି ପାରନ୍ତି ବଟ ହି ଇଜ ଦ पर्सन हु वाज अटेस्टेड
सर मोर इंस्ट्रक्शन नाही से
मोर भी इंस्ट्रक्शन नाही हैव टू गो बाय द रेकॉर्ड्स मु अपन इंस्ट्रक्शन देबी ना
सर मु के नहीं जी
नियम तो नेबे अपन कोन अछि कोन लिखो the all the 4 LTIs mentioned in the right hand margin of the order dated 9/12/2023 name of the person putting the LTI has been mentioned in the signature of the attesting advocate or maybe any other person who has mentioned their name in English. The advocate who has attested the LTIs has signed at one place. Has signed the advocates, plural advocates who have signed apparently, the advocates who have represented the defendants have signed by attesting their LTA. But to ensure compliance of the parameters laid down in Order 23, Rule 3, the learned judge, the learned senior civil judge has observed thus. One, a joint compromise petition was filed by the plaintiff and the defendants. About 37 the plaintiffs and defendants were all present on 24/11/2023, being identified by their respective counsels. 24/11 order sheet টা দেখিଛନ୍ତି? ଆପଣଙ୍କୁ ଯେତେବେଳେ ଏ ପଏଣ୍ଟଟା ରେଜ୍ କଲେ ଲୋଅର କୋର୍ଟ କାଉନସିଲ ଆପଣ ଏତିକି ଇନଭେଷ୍ଟିଗେଟ୍ କରିବାର ଥିଲା. So that would have assisted you and me. The plaintiffs and defendants filed their identity cards and passport size photographs in support of their identity and filed the joint compromise petition supported by affidavit. Next point. The plaintiffs and defendants filed Amin Badar form BODAR, Badar form and trace map showing allotment of share amongst the parties, having duly signed by the parties thereof. Next point. The contents of the compromise petition was read over and explained to both the plaintiffs and defendants, to which they admitted before the court. The parties, into bracket, plaintiffs and defendants put their LTI on the compromise petition. Stuff. Next point. The plaintiffs and defendants submitted that the compromise petition has been drafted as per their instruction. Stuff. The learned counsel for the petitioner was specifically asked what grounds the petitioners, it is John and petitioner, Mr.
John.
The petitioner has taken with regard to the above observations, public recording of fact made by the learned senior civil judge. It is fairly submitted by the learned counsel that the petitioner hearing does not dispute the recordings by the learned senior civil judge. However, he raises the points as has been noted earlier regarding attestation of LTI, the contents of the compromise petition being in English, and the Badar firm on behalf of the Badar firm with respect to the dependent number, Amin Badar firm with respect to dependent number 3 having not been submitted. In state of Punjab versus Jalorsi, reiterated in so जो तीनटा डिसीजन আছে সুপ্রিম কোর্ট जो ডিসিশনটা রিপোর্টেড ডিসিশন ভার্গবী जोटा मोड जजमेंट ଦେଇଛି ଯୋଟରେ ଭାର୍ଗବୀ ଅଛି ତାପରେ ଆହୁରି ଦିଟା ଅଛି. The scope of interference of by a higher court in exercising this jurisdiction in award made by the Lok Adalat has been authoritatively and elaborately dealt with. In view of the analysis made above regarding the satisfaction recorded by the learned Lok Adalat into bracket Senior Civil Judge Baripada. No cases made out for interference by applying the principles laid down in Jalor Singh, subsequently reiterated in Bhargavi construction. So on, Yes. At this stage, the Lord Counsel for the petitioner seeks and has adjournment. The matter shall be listed for fresh admission in the week commencing 13/7/2024.
Item 18.
So, J.M. Patnaik for the petitioner. Patnaik thile bodhe?
For the intervener.
I think I saw Mr. Patnaik. Petitioner none. Mr. None appears for the petitioner. Petitioner appearance equal to petitioner none. Mr. Anshuman Sethi, Additional Standing Counsel. Mr. S.S. Pratap, Sudhanshu Shekhar Pratap for the intervenants. None appears for the petitioner when the matter is called. None had appeared when the matter was last taken up on 4/5/2026 and the following order was passed. It is submitted by the learned counsel for the interveners that though the matter is kept pending for the last 13 years, the petitioner is not taking steps. Rather, has been consistently defaulted in appearing before the court. The matters shall be listed for orders the week commencing 13/7, indicating that it shall be disposed of. Copy of this order along with the order dated 4/5/2026 shall be forward shall be intimated to the learned counsel for the petitioner by the registry. Yes, next.
19.
Mr. Pratap. ମୁଁ ଦିଟା ମୋର ଦେଖିଲି ଦିଟା ତା ଆଗରୁ ଥିଲା କି ଡେଟା ଆଗରୁ ଆପିଲ କରିନଥିଲି ଆଜ୍ଞା 13 ବର୍ଷରେ 5-7ଟା ହବ ଆଜ୍ଞା 50-70 ହେଲେ ବି ବଡ କଥା ନୁହଁ ଆମର କିଛି ଦିନ ପରେ କଣ କହିଲେ ସିଲଭର ଜୁବଲି କେସେସ୍ ଏମିତି କରିକି ଗୋଟେ କରିବା ପରେ ବର୍ତ୍ତମାନ ତ 20 ବର୍ଷ ବି ଲିଷ୍ଟ ହଉଛି 20 ବର୍ଷ ଲିଷ୍ଟ ହଉନି ହଉଛି ଆଜ୍ଞା ଆପଣ ତ you are not impacted there is no interim order. So that difficult question you could not answer. Upon if you are agreed by any order or an interim order, you file a simple application for intervention and along with that vacation of interim order. Salla.
Director office matter pending.
Director office court will not be guided by that. If there is an interim order, obviously you have to file that for modification or vacation, whatever. Yes, next.
19.
Mr. Umacharan Misra for the petitioner, Mr. Om Swarup for the opposite party. The matter being in the list for orders is mentioned by the learned counsel for the parties. It is submitted that there is a possibility of it is submitted by the learned counsel for the opposite party that there is a possibility of the matter being settled. The parties agreeing to a amicable settlement acceptable to both. The matter shall be listed for orders in the week commencing 13/7/2026.
Item 20.
20. Yes, Mr. Na. Just give me a second.
As per the direction, I have filed affidavit explaining the maintenance order passed in different court. But since
Why is the other side, Mr. Das?
Only one occasion he appeared through VC, but thereafter did not come. Therefore, I could not serve a copy of the affidavit.
No, I understand that it will be difficult, almost impossible that unless local council nothing sir kimti
I may be permitted to send a copy through.
better. Mr. Sambhucharan Nath Sharma for the petitioner. Opposite party say waiting re achonti ki? Eta ko jaga re? Koti? Bhadrak.
Bhadrak.
But at times the lawyers are saying that if the Ross ହେଇଯାଉଛି ଆପଣଙ୍କର ଯୋଉ VC, तो slot ମିଳୁନି. Sambalpur, Mr. Devtak said that. But during the course of the day they appear. ମାନେ 5 over ହେଇଗଲେ ସେ ଉପରଓଳି appear କରୁଛନ୍ତି. କହୁଛନ୍ତି ସେଠି ବହୁତ ଲୋକ already ତାଙ୍କୁ ଦେଇ ଦିଆ ହଉଛି. ଆପଣ ପଠେଇ ଦିଅନ୍ତୁ better ହବ ଏଥିରେ. Waiting ରେ କିଏ ଅଛନ୍ତି? Waiting hall ରେ? Yes. Mr. Sambhucharan Nath Sharma for the petitioner, opposite party flag. The learned counsel for the petitioner refers to the order dated 16/3/2026 and submits that he has filed affidavit as observed in the said order. It is submitted that the learned counsel for the opposite party appeared through BC once, and since he is not a local counsel, there is difficulty in serving the copy, and he shall forward the copy of the affidavit by registered post with AD to the learned counsel as per the address given in the Wakalatnama.
No, address given in the petition.
ଆପଣ କହୁଛନ୍ତି ତାଙ୍କ ପାଖକୁ ପଠେଇବେ? ଭଦ୍ରକ ବାର ଆସୋସିଏସନ ପଠେଇ ଦିଅ ବେଟର।
ମୁଁ ଭାବୁଥିଲି direct to the party.
ତାଙ୍କୁ ଗୋଟେ କପି ଦିଅନ୍ତୁ, ଫେର ପାର୍ଟି ତାଙ୍କ ପାଖକୁ ଆସିବେନି, ସେ ଜାଣିପାରିବେନି। Once a Wakalatnama is filed, why the copy served on the council?
Okay.
I think it's better you send to Bhadrak Bar Association. In the address of the learned counsel for the Mr. Das for the opposite party, oblique Bhadrak Bar Association, Bhadrak. ଆପଣ enrollment number ଏଥିପାଇଁ ପକେଇବେ ଯଦି ସେମ୍ ନାଁରେ ଦି ଜଣ ଥିବେ। ଗୋପୀନାଥ is a very common name. Das is a very common surname. ଆପଣ ପକେଇଦେବେ ସେଟା କି ଫୋନରେ କଥା ହେଇଯାଉନାହାନ୍ତି ତା ନମ୍ବର ଦେଇଛନ୍ତି। ଆପଣ ସେଟା ଖୋଲି ପାରିବେ ପେପରଲେସ୍? ଖୋଲି ଦିଅନ୍ତୁ ହେଲା। The learned counsel shall also estimate the learned counsel for the opposite party over phone in the number as given in the Wakalatnama. Second Wakalatnama टाକୁ टच करो, खोली ଯିବ। The matter will be listed for orders in the week commencing. This of the time they are putting. 890-825-1325. Whenever I say, I always try to first ascertain myself, then I will say. 890-825-1325. Because ଆପଣଙ୍କର ନହେଲେ ଓକିଲତନାମାରେ ଡିଫେକ୍ଟ ଦେଖୁଛି ଆଜି। ଗୋପୀନାଥ ଦାସ ଷ୍ଟାମ୍ପ ମରା ହେଇଛି, ତାଙ୍କ ସିଗ୍ନେଚର ତାପରେ ତା କାଳିରେ ଅଛି। O1365 of 2006. Yes, next.
Welcome Singh Kodisa.
Kodisa. Yes.
22.
So Suryakanta Das. Suryakanta Das ଥିଲେ। ଏଇଟା ଆର୍ଜନ ହେଇନି, ଆଉ ଗୋଟେ ମାଟ ତାର। ପାସ୍ ଓଭର କରିଦେବା ନା କଣ? ଏଟା କଣ ମିଷ୍ଟର ରେ?
Filed an application for vacation of the stay granted by your lordship.
Take on trial stage, trial ପାଇଁ।
That the order has been modified by the current High Court by reducing the quantum of maintenance.
ସେ reduced amount ଟା ପାଉଛନ୍ତି?
That I am paying 12,000. You must be pleased to direct. I was making payment of the earlier amount 27,000 per month. So out of 37 it became difficult to make payment. So I have filed an application. But I have been making payment last 2 months 12,000.
ଆପଣ ଯଦି ପାଉ ମାନେ ଆପଣ ଚାହୁଁଛନ୍ତି ଆପଣ ଦବା ପାଇଁ ରାଜି ନା ନ ଦବା ପାଇଁ ମୁଁ ଆକ୍ଚୁଆଲି ବୁଝିପାରିଲି।
ରିଡ୍ୟୁସ କରେ ମୋ ପେନସନ ହେଇଗଲା ପରେ 37 ରୁ ମୁଁ ଆଉ 27 ଧରି ଏଲିୟର
କମ୍ପ୍ୟୁଟେଡ ଭ୍ୟାଲ୍ୟୁ କେତେ ପଚାରନ୍ତୁ?
12,000
କମ୍ପ୍ୟୁଟେଡ ପେନସନ ନେଇ ଯାଇଛନ୍ତି? ହଁ ସେଥିରୁ ଦେବେ ନା ଆଉ।
Even if you lordship add it also, it will come at 50,000.
50,000 ଟା 40% କେତେ ହଉଛି? 20,000। ଆପଣ ଦଉଛନ୍ତି କେତେ?
50,000 ର ମାଇଲ
40%. I am following that High Court decision of 40%. 40%. Supreme Court ରେ ବି ଗୋଟେ ଦିଟା ଅଛି, but High Court ର ତ ଗୋଟେ 40%.
Supreme Court decision is 30%.
40% ବି ଅଛି.
Difficult to sustain.
ଆପଣ ସେତିକି ନେଇ ଚଳନ୍ତୁ. 30% ଆପଣ ରଖିକି ବାକି ପଇସାଟା କୋର୍ଟରେ ଡିପୋଜିଟ୍ କରନ୍ତୁ, ଦେଖିବା କ'ଣ ଆପଣଙ୍କର ହଉଛି। ଆପଣ ଯେତିକି ଚାହୁଁଛନ୍ତି ସିଏ ଚଳିବେ 30% ରେ, ଆପଣ ଯେମିତି ଚାହୁଁଛନ୍ତି ଆପଣଙ୍କ ଜୀବନ ଅଛି, ଆପଣ ଚଳିବେ 30% ରେ, ସିଏ ଚଳିବେ। ଆପଣ 30% ରେ ଚଳନ୍ତୁ, ତାଙ୍କୁ କିଛି ଦବାନି, ଏଠି ରଖିଦବା। ଦେଖନ୍ତୁ ସେ ବୋଗସ୍ ପ୍ଲିଜ୍ ଗୁଡା ନିଅନ୍ତୁନି ଆଜ୍ଞା। ଏଠି କ'ଣ ସବୁ ବସିଛନ୍ତି, ଯିଏ ଯାହା କହିବ ସବୁ ଏଭ୍ରିଥିଙ୍ଗ ୱିଲ୍ ବି ପରଚେଜ୍ଡ। ଆପଣ ତାହେଲେ ନିଅନ୍ତୁ 30, ଆପଣ ତାକୁ କେତେ ଦବା ପାଇଁ ଚାହୁଁଛନ୍ତି? 50,000। ସେଟା ମାଇ ଲର୍ଡ ଆକ୍ଚୁଆଲି କହୁନା, ସେଟା ସୁପ୍ରିମ କୋର୍ଟ। 37 ଆପଣ କମିଟେଡ୍ ନେଇଛନ୍ତି, ସେ ଟଙ୍କା ଉଡେଇ ଦେବେ। କମିଟେଡ୍ ପଇସାରେ କ'ଣ କଲେ? 12,000।
I have given one affidavit. I have construction a house in my village.
ହଁ, ସେଇଟା ଘର ବିକି ଦିଅନ୍ତୁ। ଆରେ ଆପଣ ଘର କଲେ, ଗାଡି କଲେ, ଦୁଆର କଲେ, କ'ଣ ମିଳିବ ସେଥିରୁ? କମିଟେଡ୍ ଭ୍ୟାଲ୍ୟୁ ଇଜ ୟୋର ଚଏସ୍। ସେଥିରୁ ଆପଣ ମିଷ୍ଟର ରେ ଆପଣ ଆର୍ଗୁମେଣ୍ଟ କରିପାରିବେ। ଆପଣ ଟୋଟାଲ କେତେ ଟଙ୍କା କମିଟେଡ୍ ନେଇଛନ୍ତି? 12 ଲକ୍ଷ, 15 ଲକ୍ଷ, କେତେ ନେଇଛନ୍ତି? ଆଫିଡେଭିଟ୍ ସେଟା ବି ମନେ ରଖିବେ ନା ଆର୍ଗୁମେଣ୍ଟ କଲା ବେଳେ। ଆଉ
$12 lakhs.
12 lakhs 30% କେତେ ହଉଛି? 3,60,000। ଗୁଡ୍। 32, 36 ଗୁଣି ଦେବେ ସେ 3,60,000 ଦେଇଦିଅ। ନା 30% ଆର୍ଗୁମେଣ୍ଟ ବୋଲି ସେଟା ଭାବି ନଥିଲେ ଯେ କୋର୍ଟ ୱିଲ୍ ଆନ୍ସର ଦିସ୍। ସୋ ସିମ୍ପଲ। ଆପଣ ଯାହା ଆପଣ 20 ଲାଖ ଧରନ୍ତୁ ନେଇଥାନ୍ତେ, ତାର ଆପଣ 6 ଲକ୍ଷ ଟଙ୍କା ଦେଇଦେବେ, ସରିଲା।
That money is not there. That 12,000 it has been already spent. So 37,000 I'm getting.
ଆପଣଙ୍କୁ ତ କୋର୍ଟ କମ୍ପେଲ କରିନାହାନ୍ତି ସ୍ପେଣ୍ଡ କରିବା ପାଇଁ, ସିଏ ତ କମ୍ପେଲ କରିନାହାନ୍ତି। You have your luxuries in your life, but that doesn't mean that the other person doesn't have a soul and a life. Nahanti, any petitioner, not Mr. Prabir Kumar Ray for the opposite party. Submitted by Mr. Ray, Learned Counsel for the petitioner, that he has, as directed by order, paragraph 8 of the order dated 28/1/2026, he has filed the affidavit. Stop. In the said order dated, in order dated paragraph 8, the following was directed. ଆପଣ ଗୋଟେ ଟୋଟାଲ କ'ଣ ପାଇଛନ୍ତି କୋର୍ଟ ଲେଖିଛନ୍ତି? ଲେଖିନା କିଛି ଲେଖିନା। Yes. Affidavit copy ଆପଣ ପାଇଛନ୍ତି? Three headings କ'ଣ? କ'ଣ ଲେଖିଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି। How you are entertaining these kind of persons? Headings माने कौन आप लिखते? Dated 25/8, 14,17,000, 12,60,000, सब कौन headings कौन? 12,60,000 commuted. Leave encashment 12/7/19.
Page 7 of my affidavit.
हाँ 12/7/19, तापरे 7/26 अपन 26,000 30% दे दियंतु। ଆପଣ 30% ବର୍ତ୍ତମାନ ଆପଣ ମନ୍ତ୍ର ନା 30% ଦେବେ ଦିଅନ୍ତୁ 24 ଲକ୍ଷ 30%, 7,80,000। ଏଟାକୁ ଆପଣ ଟୋଟାଲ ସମ କରନ୍ତୁ। ଇଟ୍ ଇଜ apparently the କଣ ଲେଖିବେ affidavit এটা ଟ୍ରାଏଲ କୋର୍ଟରେ ଫାଇଲ କରିଥିଲେ ପାରା 5 ଟା
modification that they have filed.
ଆପଣ ଯୋଉଟା ଆପଣ ଯୋଉ ରିଡ୍ୟୁସ ହେଇଗଲା ପାରା 5 ଟା ଟ୍ରାଏଲ କୋର୍ଟରେ ଥିଲା ଦେଖାନ୍ତୁ
That exactly.
ଏକ୍ସାକ୍ଟଲି ଆପଣଟା ଆପଣ ପାରା ପାର୍ଟି ଦେଲେ ଟ୍ରାଏଲ କୋର୍ଟରେ
Trial court.
ଟ୍ରାଏଲ କୋର୍ଟ ସେଟା କନସିଡର କରିଛନ୍ତି has the trial court considered you receiving 30 lakhs?
No.
ମିଷ୍ଟର ରାୟଙ୍କୁ ଚାନ୍ସ ଦିଅନ୍ତୁ। ଆଉ ମୁଁ କଣ ଜାଣିନି ଯେ ସେ ଜାଣିଛନ୍ତି ବୋଲି ଆପଣ ଯଦି ସେ ଆପଣ ତାରା ଜାଣିଥିଲେ ସେମିତି ଆପଣ ଫଟକିରେ ଆପଣ ବି ତଳକୁ ନଇକି ରହିଥାନ୍ତେ ସେ ଏପଟ ଥିଲେ ସେ ବି ଫଟକିରେ ନ କହିଥାନ୍ତେ ସେ କଣ ବୁଝିପାରୁନାହାନ୍ତି ମୁଁ କାହିଁ ତ ପଚାରୁଛି ଟୁ ସିଜନ୍ କାଉନସିଲ ନଟ୍ ଟୁ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ
No question of raising about his ability.
So he's doing his best or not? He has to do his best.
Yes, yes.
Interestingly, since the commuted aspect has been dealt with by the Honorable Justice Mishra, the Deepak Mishra has been also his then vice.
That judgment will expire.
And there are other judgments. जोटा को involuntary reduction हबो ठीटा हेले आपनकर इयो सेंटेंस कोड रहला कोड कर देबे at paragraph 5 of the affidavit, copy of which has been affidavit dated 25/2/2024, copy of which has been served on the learned counsel for the petitioner, it has been stated that the petitioner has received rupees proper calculator achi 14,17,251 plus 12,60,565 rupees 7,41,551 towards
I filed a separate memo in a tabular form.
towards commuted value of pension, which he had opted to commuted value of pension, comma, leave encashment, अलगा गोटे कोन फाइल करछन
Separate memory file with pursuant to lordship's direction.
कोर्ट टी सेट अछि
It's like
अरे सेटा मते के पढुछन रेकॉर्ड देखना कोटी कोन मेमोरी फाइल ये छाड़ दियो आपण चित्र जा लिखिन से एफिडेविट अछि सेटा थाउ आपण पारा 8 को आसन आपण को बाबत रे केते पाइछथि कोन तो सेटा हम रेकॉर्ड कर दा बेटर अरे योर लॉर्डशिप नो माने यू प्लीज पारा 5 को आसन तू जोतरे आपण पाइछथि 14 लाख 12 लाख
12 lakh 60.
14 गोटे 12 गोटे आ गोटे 7 लाख 41,000 सेतिक तो 14 लाख 17,251 प्लस 12 लाख 60,565
There is a gratuity and
ठीक है रही जाते मु तो आपण तो आशीष करना मत तो करिया फेर पड़े हम बस्ती धरि के आपण 12 लाख 60,565 प्लस 7 लाख 41,551 एटा केते होछि 14 12 26 7 33 33 1 34 34 लाख 18,000 19,000 Apparently, the receipt of the 14 lakhs 17,000 towards commuted value of pension the 12,60,565 12,60,565 towards computed value of pension was at the option of the opposite party. The 33, the amount of rupees 34 lakhs, the amount of rupees around 34 lakhs received by the opposite party has not been taken note of by the learned trial court. When the learned trial court has reduced the amount of pension being carried away by the fact that the pension has been reduced. On being asked, the learned counsel for the petitioner, opposite party submits that he is not sure whether the opposite party had apprised the learned court regarding he receiving more than 34 lakhs towards retirement dues, including commuted value of pension of rupees 12,60,565.
Flag D.
Yeah?
Flag D.
As a matter of coincidence, what document judgment? Flag D যদি ভুলে থাকে 34 লাখ সে কই না থাকে কোন ফ্ল্যাট ডি রে কোন সেটা কমি যাଉଛି কি না 35 ହେଇଯାଇଛି
Number, exact figure, page 94.
କେତେ ପେଜ 94 ଫିଗରଟା କହିବେ ନା ଆପଣ ତ ଚଲେଇଛନ୍ତି ପେଜ 94 ଫ୍ଲାଗ ଡି ମେମୋ ସିମ୍ପଲ କ୍ୱେଶ୍ଚନ ର ଗୋଟେ ଇଲାବୋରେଟ କମ୍ପ୍ଲେକ୍ସ ଆନ୍ସର କଣ ଲେଖିଲେ as a matter of coincidence, the Honorable Apex Court dealt with a similar situation when the husband had opted to take VRS. And in the words of the Honorable Apex Court, perhaps to avoid payment of maintenance in Samima Faruqi and versus Fahid Khan. The learned trial court, not noticing the fact that the petitioner, the opposite party, petitioner before it, had opted to avail loan of rupees 12 lakhs, 12,60,565, and repay the same by deducting equal monthly installments from his pension stock. But in view of the above, the judgment passed by the learned trial court, learned judge, family court, so and so, so and so. Thank you. Dated 13/5/2025 is set aside. As the learned trial court has ordered in altering its earlier order by exercising jurisdiction under section 127 of the CRPC, as it failed to take the relevant materials into consideration. The reasonings given by the learned trial court at paragraph 7 of the judgment is reproduced here. The learned court has recorded after his superannuation on 31/1/2022, there is complete change in his earning. Such sweeping observation by the learned court is bereft of any material particulars. The court has not gone into the details as discussed above, which was well within the knowledge of the opposite party. The opposite party deposed before the learned court as PW1 in the 127 in the application under 127 of CRPC. as appraised by the learned counsel for the opposite party, the opposite party had failed to disclose he receiving about rupees 34 lakhs at the time of his superannuation. Stop. The order dated 13/5/2025 passed in the criminal proceeding number 108 of 2023 under section 127 of CRPC set aside. The earlier order dated so and so passed by the learned court under section 125 of CRPC is restored. The consequences shall follow. The areas, if any, towards payment of monthly maintenance as directed by order dated dash in CRP number dash under section 125 CRPC shall be paid in 6 equal installments, if not already paid. Yes. You have filed another for enhancement. Yes, next.
She disposed of it.
Yes, yes.
23.
My lords, permit me to appear through VC, my lords. My lords, an application was filed for change of nomenclature. Earlier, my lords was pleased to direct the registry to redo the stamp reporting. So accordingly, at flag B, my lords, I find an explanation as to why the current application will be maintainable as revision. And my lords, at flag C is the report of the learn.
The court can review the stamp report set under which provision?
I'm sorry, my lords.
Can review a stamp report under which provision of the High Court rules?
Let's pardon me, my lords. I'll recheck, my lords.
Who am I to pardon, sir? The law has to pardon. Law has to pardon me also if I pass a illegal order.
No, my lords,
at least I must know that I can review a stamp report in sitting in judicial side.
That's the only alternative left with me before my lord is to file an application for change of nomenclature, which has already been filed, my lords, through IS 607, my lords. My lords, on change of vacat, my lords,
just actually, I'm since pursuant to our order, pursuant to the earlier order, they have submitted a report, so I'm going through that.
Yes, my lords, flag C, my lords.
So I hope you will allow me to read that.
I'm sorry, my lords.
You are saying it need not be changed from RPFA.
My lords.
I think the report says also the same thing.
My lords, in fact, the copy of the report was not supplied. Yes, my lords. In fact, earlier, pursuant to the report, my lords,
copy of the report is not to be supplied to the council.
No, it's not supplied, my lords. In fact, our explanation was filed by me saying that it is to be remanded as RPFM, basing on which, my lords, flag C has been passed.
You have filed IA for conversion.
No, it was earlier filed, my lords, by the previous council, my lords.
IA,
yes.
Mr. Swati Raut for the petitioner, IA 607 of 2025. Hello. Pursuant to the order dated 17/2/2026, the matter was placed before the matter was placed for start reporting again, and report has been furnished by the Learned Registrar Judicial, which indicates that change of nomenclature from RPFM to CRLMP is not necessary. Stop. According to the IA, stands disposed of. So it should come up for fresh admission now.
In fact, my lords, IF 507 is there for limitation, my lords. If my lords are kind to issue notice on limitation, my lords.
607.
IF 5. But my lords, IF 607 was for change of nomenclature, which my lords was disposed of.
Disposed of.
Yeah, IF 507, my lords, is for limitation, my lords. It was filed delayed, my lords.
Correct, but you will argue on merits today, or you will argue on merits, sir?
No, my lords, limitation notice has not yet gone, my lords. They might
limitation notice is here. You will not go unless you argue on merits.
My lords, might fix a short date, my lords. I'll appraise this course on merits.
Here the court is not a post office. Wherever
No. I'm sorry, my lords. I didn't mean to say that, my lords. I can place the facts on merit. I'm sorry, I didn't mean to say that, my lords. I'll place the facts on merit, but we'll put a short date.
Or it will be on another day.
But sir, any other date, my lords.
Matter shall be listed for fresh admission in the week commencing.
27.
27.
Great, sir, my lords. That's earlier date will also do, it's subject to my lords' convenience.
27 ନାଇଁ ଆପଣଙ୍କର କେବେ ଚାହୁଁଛନ୍ତି?
My lords,
ମୋର କନଭିନିୟନ୍ସ ଏଠି ଖୋଜା ହଉନି ଏଠି ଆପଣ
my lords, as early as possible, subject to my lords' convenience. As early as possible.
27 27 ଅଛି ଠିକ ଅଛି 27
24.
On behalf of D Tripathi, I am appealing for the petitioner. 2 weeks time, pray for 2 weeks time for the.
Better Mr. Raut is there. You are there. You are Mr. Swain.
Yes, Palai.
Mr. S. Palai on behalf of this is for what? Order से कहेंगे अस्ति sir?
First item is limitation.
First matter आपण appear कौन ना Mr. What's your name, sir?
Sir, Hitesh Kumar Sahoo.
Mr. Sahoo, why you are not Mr. This is item 23.
I am appearing the second matter. I am appearing the second case.
Second is you are appearing on behalf of the husband or the wife.
Husband.
ଆପଣ ଏଥିରେ appear କରିବାର instruction ନାହିଁ?
नहीं. बिना में गुटे.
गलत नाम तो नथियो, but since both are tagged together, you should appear. नहले problem हबो ना एमती कले केमती हबो?
I will take instruction from.
गुटे matter tag हबो, तापरे आउथरे notice दिबो, but other side has appeared already. Mr. S. Palai for the petitioner, opposite party blank. The matter is listed along with the connected RPFM 216/2024. Stop. In the said petition, Mr. Sahoo, your name is not there.
No, my lord, I have no power in that matter.
Mr. Debasis Tripathi and Learned Counsel and Learned Associates have appeared on behalf of the opposite party. On behalf of the petitioner therein, who is the opposite party in the present application. Stop. Mr. Sahoo, Mr. Hitesh Sahoo. Mr. Hitesh Sahoo, Learned Counsel, appears on behalf of Mr. Tripathi, Learned Counsel. He submits that he shall obtain instruction if Mr. Tripathi will be appearing for the opposite party in the present application. The matter shall be listed for orders in the week commencing. 27. Okalata maanatu.
Yes.
Next matter likhibe Mr. Hitesh Sahoo on behalf of Debasis Tripathi for the petitioner. Mr. S. Palai for the opposite party. The matter shall be listed along with the connected RPFM 409/2025. in the week commencing 27/7. Yes.
25 to take it of 1 week after Mallard.
The Bharat Bhushan Rautray for the petitioners. Opposite party plan. The matter was listed on claim 16/4/2026 and on 5/5/2026 and adjourned by the Learned Counsel for the petitioner on both the occasions. Today, the matter being listed for orders, again adjournment is sought for. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing 13/7. 20/7/2026.
26.
My Lord, I'm
Ms.
happy.
Namita Patnaik for the petitioner, opposite party plan. Yes, Ms. Patnaik.
My Lord, I'm challenging the judgment and dated 3/4/24, my Lord, where no notice was served on me, my Lord. So, Lordship may see page.
So, no notice served means we have to show the
My Lord,
order.
Lordship may see page 23.
Certificate
my
copy
Lord.
ଆଣିଛନ୍ତି?
हाँ ଦେଇଛି voter file ଦେଇଛି 23, my Lord. My Lord, what happens, my Lord?
Page 23 କହୁଛନ୍ତି?
ଆଜ୍ଞା ସେଠି କହିଲେ notice to OP in both ways and put upon 2/2/23 for SR and PA. ତାପରେ sir 2/2/23 counsel for the petitioner is present, previous notice not sent as yet. To avoid delay, fresh notice be issued to the OP fixing 10/3/23. Then 10/3/23 counsel for the petitioner files Hajira put upon 15/5 for SR and PA. Counsel for the petitioner files a petition to issue notice to the OP through special peon. Hard same is allowed. Notice be issued to the OP through special peon. Well, no notice.
11/10
Again?
11/10/2023 ପଢିବେ।
Petition via SR not back and attached with record put upon for consideration.
ଆରେ ଆଉ ଥରେ ପଢନ୍ତୁ।
Petition SR back and attached with
ସରଲା,
record
sufficient.
put upon 9/11/23 for consideration of SR.
ହଁ।
ଏଇଟା ହଉଛି special peon name. Not
Whatever.
not
Whatever.
that they have issued.
ସ୍ପେଶାଲ ପିଅନ ଗୁଆ ନିମନ୍ତ୍ରଣ ସେଥିରେ କଣ how does it make a difference?
Sir,
ଆପଣ when you are taking a specific plea of the notice not being served and the
My
court has taken note of the SR by the special peon, it is enough.
No, sir. Your Lordship may see the 67 of.
ଆରେ 11/12 ପଢନ୍ତୁ ଆପଣ।
ଏଥିରେ sir କହୁଛି ସେଇ special
ଆପଣ
peon.
ଶୁଣନ୍ତୁ, ଆପଣ first of all it's a mixed question of fact and law.
ଆଜ୍ଞା
Whenever you are taking a specific plea, ଆପଣ ଯେତିକି ଚାହିଁବେ ପଢିବେ ବାକିଟା ପଢିବେନି ସେଟା
ନାଇଁ,
ମୁଁ କରିପାରିବି।
ପଢିବୁ।
ଆପଣ 11/12 ପଢନ୍ତୁ। ଆପଣ ତ ଅଟକିଲେ ନା ସେଠି ଆପଣ ସେତେବେଳେ ମୁଁ
ଆଜ୍ଞା,
ପଚାରେ 11/12 ଅର୍ଡରଟା ପଢନ୍ତୁ।
Hajira, the record is posted.
କଣ ହାଜିରା
On
କହୁଛି?
perusal of SR.
Petitioner files ହାଜିରା ପୁରାଟା ପଢିବେ।
Petitioner files Hajira.
ଇଂଲିଶ ଟା ଗୋଟେ ୱାର୍ଡ ପଢିଲେ କେମିତି ହବ?
The record is posted today for consideration of SR. On perusal of SR, it reveals that the process server returned the SR with endorsement, refusal of summon by OP. Petitioner also filed service affidavit to that effect.
Sorry,
Hence, the notice against the OP is sufficient. Sir, ମୁଁ ଏଠି ଦେଖଉଛି ଆପଣଙ୍କୁ ଯୋଉ ସ୍ପେଶାଲ ପିଅନରେ ସେ ନୋଟିସ ପଠେଇଛନ୍ତି କିନ୍ତୁ ଆଉ
ଏଠି ଦେଖାନ୍ତୁନି।
ଆଜ୍ଞା
ଏଠି ଦେଖେଇ ନଥାନ୍ତେ ସେଠି ଦେଖେଇଥାନ୍ତେ ମୁଁ କଣ ତାଙ୍କର ଇଏ ଶିରସ୍ତାଦାର ନା କଣ?
ନାଇଁ ସେଇଟା ମୁଁ
ଆପଣ if you want to dispute you should have filed that there not here.
ନାଇଁ ସାର୍
First of all ଆପଣ order 9 rule 13 ଫାଇଲ କଲେ କି ସେଇ ଗ୍ରାଉଣ୍ଡ ରେ?
ନାଇଁ 126 ସେ ଫାଇଲ କରିନି କାରଣ ଯେହେତୁ ସାର୍ ଆପଣଙ୍କ ପାଖକୁ ଯୋଉଥିପାଇଁ ଆସିଛି ଯେ ମୁଁ ନୋଟିସ ପାଇ ନାହିଁ ମତେ ଯେତେବେଳେ
ମ୍ୟାଟର ଅଫ ସ୍ପିଚ ନୁହଁ। ଆପଣ ଯେମିତି କହୁଛନ୍ତି ମୁଁ ନୋଟିସ ପାଇ ନାହିଁ କୋର୍ଟ ତାଙ୍କର ବଢିଆ ଲେଖିକି ଦେଇଛନ୍ତି ନୋଟିସ ପାଇଛନ୍ତି ବୋଲି।
ନା ମୁଁ ମତେ ଏଠି ରିଫ୍ୟୁଜାଲ ତାପରେ ଏ ଯୋଉ ଲୋକ
ରିଫ୍ୟୁଜାଲ ହେଲେ
ଆଜ୍ଞା
କୋର୍ଟ ଇଜ ନୋବଡି ଟୁ ରେକର୍ଡ ଦ୍ୟାଟ ନୋଟିସ ଇଜ ନଟ୍ ସଫିସିଏଣ୍ଟ। କୋଉ ପ୍ରୋଭିଜନ ଅଛି ରିଫ୍ୟୁଜାଲ?
ସାର୍ ଅଛି
ପଢନ୍ତୁ।
ଆପଣଙ୍କର ସାର୍ ଦିଟା ଆଗ କୋର୍ଟ ପ୍ରୋସେସ ରେ ଯିବ।
ଶୁଣନ୍ତୁ
ନୋଟିସ ଟା ସାର୍ ନୋଟିସ
ଯୋଉ ଶୁଣନ୍ତୁ ଆପଣ ଗୋଟେ ପୁରା ଭୁଲ ସବମିଶନ କରୁଛନ୍ତି। ଯେ କୋର୍ଟ ପ୍ରୋସେସ ରେ ନ ଯାଇଥିଲେ ସ୍ପେଶାଲ ପିଅନ ଗଲେ ନୋଟିସ ସଫିସିଏଣ୍ଟ ହବନି।
ସାର୍ ମୁଁ ଡିସିସନ ଦେଉଛି
କିଛି ଡିସିସନ ନାହିଁ।
ଡିସିସନ ଦଉଛି ଦିଟା ଡିସିସନ ସାର୍
ପଢନ୍ତୁ ପଢନ୍ତୁ ଡିସିସନ ପଢିଲେ ହବ ନା ଦେଲେ କଣ ହବ ଏମିତି କୌଣସି ଡିସିସନ ନାହିଁ
ସାର୍ ଦିଟା ଡିସିସନ ଏଥିରେ ମୁଁ ଗୋଟେ
ସ୍ପେଶାଲ ପିଅନ ନୋଟିସ ଟା ଯଦି ସଫିସିଏଣ୍ଟ ହେଲା
ଆଜ୍ଞା
ତାହେଲେ ନୋଟିସ ଇନସଫିସିଏଣ୍ଟ ରିଫ୍ୟୁଜାଲ
ସାର୍ ଦିଟା ରିଫ୍ୟୁଜାଲ ରେ ସାର୍ କେମିତି ଆଗ ନୋଟିସ ଯିବ ଆଗ କୋର୍ଟ ପ୍ରୋସେସ ରେ ଯିବ 67 କମ୍ପ୍ଲାଏ ହେଇନି
ଦ୍ୟାଟ୍ ଇଜ ୟୋର ଇମାଜିନେସନ
ନାଇଁ ନାଇଁ ସାର୍ ଇମାଜିନେସନ କାହିଁକି ମୋ ପାଖକୁ ନୋଟିସ
ଆପଣଙ୍କର ଆପଣ ଶୁଣନ୍ତୁ ସମୟ ନଷ୍ଟ କରନ୍ତୁନି we are already over the beyond the time you cite a single decision where special peon notice if refused shall be cannot be treated as sufficient
ନା ମୁଁ ସାର୍ ସେ କଥା କହୁନି
ତ ଛାଡ,
66 ଟା 67
ଛାଡ଼ନ୍ତୁ ତାପରେ ଯଦି ବି କୌଣସି ଡିସିସନ ଅଛି ଯେ ଆପଣଙ୍କର ସ୍ପେଶାଲ ପିଅନ ନୋଟିସ ଇସ୍ୟୁ ହେଇପାରିବନି ସେଟା ବି ଦେଖାନ୍ତୁ
ତାହେଲେ ସାର୍ ଆଉ ଗୋଟେ
ନାଇଁ ଆଉ ଗୋଟେ ଦିନ ଆଜି ସରିଲା
ଆଜି
ଏଠି ଆଜ୍ଞା ଏଠି ସେମିଫାଇନାଲ କ୍ୱାର୍ଟର ଫାଇନାଲ ଏଟା କଣ ୱାର୍ଲଡ କପ୍ ଫୁଟବଲ ଖେଳ ହଉଛି ନା
ସାର୍ ଦେଖନ୍ତୁ ମୁଁ ପଢୁଛି ଏଇଠି
ଶୁଣନ୍ତୁ ପଢନ୍ତୁ ପଢନ୍ତୁ ଭୁଲ ଭାଲ ପଢିଲେ କେମିତି ହବ
ନାଇଁ
we are being watched madam we are being watched
89 ର ଡିସିସନ ଗୋଟେ ଅଛି ସାର୍
ସେମିତି କୌଣସି ଡିସିସନ ନାହିଁ
ଅଛି ସାର୍
ପଢନ୍ତୁ ପଢିଲେ ବୁଝିବେ
this revision is directed against the order passed by the learned subdivisional judicial magistrate Bhadrak refusing to set aside the ex parte order of maintenance passed
ଆପଣ
against
କଣ ପଚାରିଥିଲେ ଅର୍ଡର 9 ରୁଟ 13 ଫାଇଲ କରିଥିଲେ 123
order 9 rule
ଆପଣ ସେଇଟା ଅଲଗା ଜିନିଷ
ଟା ହବ
ସେଇଟା ଅଲଗା ଆପଣ
ନାଇଁ
ସଫିସିଏନ୍ସି
ସେଟା ଫାଇଲିଂ
ଛାଡ଼ନ୍ତୁ ତାହେଲେ ସେ କେସ୍ ଗଲା ସଫିସିଏନ୍ସି ଅଫ ନୋଟିସ ରେ ମୁଁ ସେଇଥିପାଇଁ କହିଥିଲି ଯେ ଦ୍ୟାଟ୍ କୋର୍ଟ କୁଡ୍ ହାଭ୍ କନସିଡର୍ଡ ରିଭିଜନାଲ କୋର୍ଟ କ୍ୟାନଟ ଆପଣ ଯୋଉଥିରେ କହୁଛନ୍ତି ଯେ ଆଗ କୋର୍ଟ ପ୍ରୋସେସ ରେ ନୋଟିସ ସଫିସିଏଣ୍ଟ ନହେଲେ ସ୍ପେଶାଲ ପିଅନ ହେଇପାରିବନି ସେଇ ପଏଣ୍ଟରେ ଅଛି ଯଦି କିଛି କେସ୍ ଦେଖାନ୍ତୁ କେସ୍ ର
ସାର୍ ଏଠି notice under the provision of section 66 of code was not served on the petitioner ଏଥିରେ ସାର୍ ସେ କଣ
ଫେର ଓଡିଆ କମେଣ୍ଟାରୀ ଦେଲେ
ଆଜ୍ଞା
ଜଜମେଣ୍ଟ ଟା ପଢନ୍ତୁ
ସାର୍ ଏଇଟା ମୁଁ ଆପଣଙ୍କୁ
ଆପଣ ନିଜେ
ଦଉଛି
ପଢିବେ
ମୁଁ
ମୋର ଆଜ୍ଞା ପଢିବା ଦରକାର ଆପଣ ନିଜେ ପଢନ୍ତୁ ମୁଁ ତ ଆଇ ଏମ୍ ନଟ୍ ଡାଉଟିଂ ୟୁ ଆପଣ ଦି ଲାଇନ ପଢିଲା ପରେ ଗୋଟେ ଓଡିଆ କମେଣ୍ଟାରୀ ଦଉଛନ୍ତି ସବୁ
ସାର୍
ଜଜମେଣ୍ଟ
2014
2014 କଣ 1914 ହେଲେ ବି ଚଳିବ ସେଥିରେ କଣ ଅଛି
ଏଥିରେ ସାର୍
ମତେ ଏକ୍ସପ୍ଲେନ କରନ୍ତୁନି ଆପଣ
କହିଦଉଛି
ଆପଣ ଯୋଉଟା ଆପଣ କିଛି ନ କହିକି ଯୋଉ ପାର୍ଟଟା ରିଲାଏ କରୁଛନ୍ତି ପଢନ୍ତୁ ୱିଥ କନସେଣ୍ଟ୍ରେସନ
ଆଜ୍ଞା brief facts of the case are that the OP filed a petition under section 125
ସେଟା କଣ ପଢୁଛନ୍ତି ଆଜ୍ଞା ଆପଣ ତ ନୋଟିସ ପାର୍ଟକୁ ଯିବେ ସେଠି ପଢିବେ ତାପରେ କହିବେ ଯେ he traveled to the court by car after alighting from the car he had मूंगफली and चना इस तार कौन अच्छी relevance अपन स्टेट में से जान तू जोटा अपन आर्ग्यू करछन
on 28/11/2003 SR was not back on 23/12 the SR was also not back the order dated 22/1/2004 reveals that
देखिए अटकी जीवे सेठी
again
SR not back
again
हला एठी कोन है
एठी सर मोर एठी को हिची ना स्पेशल पियोन रे देले
अपन का SR हिची ना नहीं
SR माने सर स्पेशल
माने कोन
पियोन
स्पेशल पेन गोटे नराधम ताको पचरी
ना 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 आपनकर आगो कोर्ट प्रोसेस सल्ला परे
सुनନ୍ତୁ ସେଇଟା ଆପଣ ଗୋଟେ ଭାଷଣ ଦଉଛନ୍ତି
ना ना सर भाषण
सर ଆପଣଙ୍କର इंडिविजुअल परसेप्शन योर इंडिविजुअल परसेप्शन ऑफ लॉ आई कैन नॉट इवन एबे मते ठीक लागुची मते बहुत बढ़िया लागुची आपण आर्गुमेंट बट आई कैन नॉट कमिट इलीगली लाइक दिस
आई वांट टू कन्विंस युअर लॉ
नो 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 इलीगल कन्विंसिंग इज नॉट कन्विंसिंग आपणकर
ए जो दीटा
आपणकर स्पेशल आपण जोडा कहउचंती द स्पेशल पियर नोटिस कैन नॉट बी काउंटेनेंस बिकॉज़ द नोटिसेस आगुरु कोर्ट प्रोसेस रे ही नथला बोली
एथरे सर पठेइथिले
दैट इज एब्सर्ड दैट इज एब्सर्ड
रजिस्टर पोस्ट रे पठेइदेले सर
आपणकर जोटा पढुचंती यू हैव मिस द पॉइंट एसआर नॉट बैक एसआर नॉट बैक है अलगा जिंस दार इंटरप्रिटेशन हो
सर थ्रू स्पेशल पियन माने आगुरु मूलरु नोटिस जीवन नै थ्रू स्पेशल पियन
आगे मूल नोटिस अगर
एथरे सर आसिला ये कोन आसिला ये कहि दे
मिस पटनायक कोर्ट नोटिस इज ए कोर्ट नोटिस इट इज नॉट ए मूल नोटिस और अगर नोटिस
ना सर
स्पेशल पियन नोटिस इज ए कोर्ट नोटिस
मोना कि स्पेशल पियन सर कोठी जीवो को सर्कमस्टेंसेस रे स्पेशल पियन नोटिस पठा
आपनकर मेन प्रॉब्लम हला यू आर नॉट प्रिपेयर्ड
Sir,
ଆପଣ
ମୁଁ
କୋର୍ଟ ରେ
prepare
ବ୍ଲକ୍ ମାରଲେ ହବନି ଆଟଲିଷ୍ଟ
ନାଇଁ
କୋ
sir,
କୋର୍ଟ ରେ ହବନି
sir,
ଡୋଣ୍ଟ ଡୁ
prepare
ଦ୍ୟାଟ୍
ହେଇଛି ମୁଁ sir ଏଇଟା
ଡୋଣ୍ଟ ଡୁ ଦ୍ୟାଟ୍ ଆପଣଙ୍କର ସେଥିପାଇଁ କହିଲେ ଆପଣ ଯୋଉ ଡିସିଜନ ଉପରେ ରିଲାଏ କରୁଛନ୍ତି ସେଟା ପଢନ୍ତୁ ଡୋଣ୍ଟ
ପଢୁଛି
गिव
sir।
मी ए କମେଣ୍ଟରୀ ମୁଁ ବହୁତ ଇମ୍ପ୍ରେସ୍ଡ ଆପଣଙ୍କ କମେଣ୍ଟରୀରେ ବଟ୍ କ୍ୟାନ୍ ଆଇ ଡୁ ଦ୍ୟାଟ୍ କ୍ୟାନ୍ ଆଇ ଆକ୍ସେପ୍ଟ ଦ୍ୟାଟ୍
The order dated 22/1/2004 reveals that the OP who is the present petitioner was absent on repeated calls. SR against him is with a report that he refused to accept the notice. The service was treated as sufficient and he was set expiry. Thereafter, on 24/5/2006, the SDGM allowed the prayer of the OP with a direction to P2000 as maintenance. Against that order, the petitioner preferred the earlier revision before this court.
ସେଟା କହୁଛନ୍ତି ଷ୍ଟେଟ୍ ଏବେ ଆପଣ ସର୍ଭିସ ପାର୍ଟ କୁ ଯାଆନ୍ତୁ ଆଜ୍ଞା 4:10 ହେଲାଣି
Sir, say 8
ଆପଣ ସର୍ଭିସ କୁ ଯାଆନ୍ତୁ ସିଧା ଏଇଥିରେ ନି ସିଧା ଷ୍ଟେଟ୍ ଏବେ ସେ ଲାଇନ କୁ ଯାଆନ୍ତୁ
proof of service in such cases and when serving officer not present. When a summons issued by a court is served outside its local jurisdiction and in case where the officer who has served a summons is not present at the hearing of the case, an affidavit purporting to be made before a magistrate that such summons has been served and a duplicate of the summons purporting to be endorsed in the manner provided by section 62 or section 64 by the person to whom it was delivered or tendered or with whom it was left shall be admissible in evidence and the statements made therein shall be deemed to be correct unless and until the contrary is proved. The affidavit mentioned in this section may be attached to the duplicate of the summons and returned to the court. The impugned order has been Section 67 and 68 of Criminal Procedure Code. Since the petitioner is residing at Pancteria under Orajang PS, which is outside the jurisdiction of the SDGM Hon'Ble, the process server.
against it kind of side କରୁଛନ୍ତି this is clearly against you here the court peon himself has returned the SR within the jurisdiction.
Sir, ମୁଁ ସେଠି କହୁନି sir, ମୁଁ କହୁଛି ଗୋଟେ special
sir madam ଆପଣ ଯଦି ଗୋଟେ ୟାଡୁ ସଡୁ କହିବେ ସେଟା ଗୋଟେ ଆର୍ଗୁମେଣ୍ଟ ହେଇଯିବ ଆପଣ ତ ସେତେବେଳେ ଚେଷ୍ଟା କରୁଛନ୍ତି ସେ ପଏଣ୍ଟ ରେ ଆପଣଙ୍କୁ have been patiently listening to you
sir ମୁଁ ଏଇଟା
that special peon notice without issuance of notice by the court process.
sir ଏଇଟା ମୁଁ ଟିକେ ପଢୁଛି sir ଏଇଟା
କୋନଟା ପଢୁଛନ୍ତି ସେଟା
ଏଇ ଯୋଉ 67 ଟା ଆମ ଯୋଉ ନୋଟିସ ପାର୍ଟଟା sir
67 of CRPC ପଢୁଛନ୍ତି
CRPC ଟା ଏବେ ଏଟା ଯୋଉ
BNSS ପଢୁଛନ୍ତି
equal ହଁ 62 ହେଇଯାଇଛି
ବ୍ଲୁ ବୁକ୍ ଟା ଆଣ ଆରେ ବ୍ଲୁ ବୁକ୍ ଆଣନ୍ତୁ BNSS ଓ ଖାଇବା ସାଙ୍ଗରେ ଆଉ କିଛି ନଉଛନ୍ତି କି ଆରେ ମୋଟା ନେଇଗଲାଣି ବହିଟା କିଏ ନେଇଗଲାଣି କଣ ଲାଇବ୍ରେରୀ ଲାଇବ୍ରେରୀ ବହିଟି ଥିଲା ଆପଣ କାହିଁ ଲାଇବ୍ରେରୀରୁ କାଢିବେ ରୁମରୁ ଯାଇ ଜଣେ ଆଣନ୍ତୁ ଆଉ କଣ ପଢନ୍ତୁ ସେ ଏକା ପାରିମେଟ୍ରିକ ପଢିଲେ ଚଳିବ ଆଜ୍ଞା
summons how served. Every summons shall be served by a police officer or subject to such rules as the state government may make in this behalf.
ଏଥିରେ ପୋଲିସ ଅଫିସର ଅଛି
ଆଜ୍ଞା
125 ପୋଲିସ ଅଫିସର ସର୍ଭ କରିବ
ପ୍ରୋସେସ ସର୍ଭର ସାର୍ ମୁଁ କହୁନି ମୁଁ କହୁଛି
ଛାଡ଼ନ୍ତୁ,
ଦିଟା ସାର୍ କୋର୍ଟ ପ୍ରୋସିଡିୟର ଦିଟା
ଆପଣଙ୍କର ଆପଣଙ୍କ ଆର୍ଗୁମେଣ୍ଟ ହେଲା ଯେ ସ୍ପେଶାଲ ଆପଣ ଫାର୍ଷ୍ଟ ଅଫ ଅଲ୍ ୟୁ ୱାଣ୍ଟେଡ ଟୁ ଆଭଏଡ୍ ଦୋଜ ଅର୍ଡର୍ସ
ନାଇଁ ନାଇଁ ସାର୍ ଅର୍ଡର
ଆପଣ ପଢିଲେନି ମୁଁ କହିଲା ପରେ ପଢିଲେ
ହଁ
and the court has given a finding ଏଇଟା ରୁମ ଏକ୍ଜାମ ଏଇଟା ପଢେ ଆପଣ ବହି ଅଛି ହେଲେ ମନ ଦୁଃଖ କରିବେନି ଆପଣ ହସୁଛନ୍ତି ମନ ଦୁଃଖ ଦୁଃଖ କରନ୍ତୁ ଠିକ ଅଛି ୟେସ୍
ସାର୍ 64 ମୁଁ ସାର୍ କହୁଛି
ଆପଣ ଶୁଣନ୍ତୁ ଆପଣ ଗୋଟେ ହାଫ୍ ପ୍ରିପାରେସନ ଠିକ ଅଛି ଯେ ଆପଣଙ୍କର ଶୁଣନ୍ତୁ ଆପଣ କହୁଛନ୍ତି ଯେ ସ୍ପେଶାଲ ପିଅନ ରେ ନୋଟିସ ଇଜ ନୋ ନୋଟିସ
ନାଇଁ ମୁଁ ସେଇଟା କହୁନି ସାର୍ ମୁଁ ସେଇଟା କହୁନି ସାର୍ ମୁଁ କହୁଛି କୋର୍ଟ ରୁ କେମିତି ଯିବ ଯେମିତି ସିପିସି ରେ
ଆଜ୍ଞା, ସେଇଟା
ଅର୍ଡର
ସେଇଟା ସେଇଟା ଆଜ୍ଞା କୋର୍ଟ ପଠେଇ କିଛି ଭୁଲ କରିନାହାନ୍ତି ସ୍ପେଶାଲ
ନା କାରଣ ସ୍ପେଶାଲ ପିଅନ ଟା ସାର୍ କୋଉ ସର୍କମସ୍ଟାନ୍ସେସ୍ ରେ ଦିଆଯିବ ସେଇଟା କୋର୍ଟ କଲେନି କୋର୍ଟ ସ୍ପେଶାଲ ପିଅନ ର କାରଣ ଆଗରୁ
ଆଜ୍ଞା
ଯେତେବେଳେ
ଆପଣ ସ୍ପେଶାଲ ପେନ୍ ନୋଟିସ ରିସିଭ କରିଛନ୍ତି ନା ରିଫ୍ୟୁଜ କରିଛନ୍ତି?
ମୁଁ ସାର୍ ରିସିଭ ମୁଁ ମୂଳରୁ ପାଇନି ଜମା
ଠିକ ଅଛି।
ମୁଁ
So
ତ
ସେଇଟା-
ପାଇଥିଲେ ମୁଁ ଆସିଥାନ୍ତି
ସେଇଟା ଆପଣ ଯୋଉ ଅର୍ଡର 127 ଫାଇଲ କରି
ନା 126 ଟା
ଗଲା
ଫାଇଲ
ତେଣୁ ସରିଲା।
126 ଟା
ମୁଁ ନା ପିଓନ ନା ଏସଡିଜେ ମୁଁ କିଛି ନୁହଁ। ମୋର ସେ ପାୱାର ବି ନାହିଁ ଆଜ୍ଞା ଟୁ ରିଭ୍ୟୁ କରିବା ପାଇଁ ସଫିସିଏନ୍ସି ଅଫ ନୋଟିସ ବାଇ ଏସଆର I cannot. Just now I was discussing with Mr. Raut that whether a staff report can be judicially interfered. Of course, in that case, it did not arise because say staff report भी सेया कुछ. See the argument कले से भाविले होते staff report अलगा अछि. But staff report said that RPFM is maintained.
ସାର୍ ମୁଁ ଗୋଟେ କଥା କହୁଛି
Sir, ଆପଣ मैडम ଆପଣ जोड़ा कहले ଆପଣ ଲାଗୁଛି ମୁଁ ବୁଝି ପାରନି ବୋଲି.
ନା ନା ମୁଁ ସେଇ କଥା
ବୁଝିଲା ପରେ ଆପଣଙ୍କୁ ପଚାରିଲି ଯେ ସ୍ପେଶାଲ ଆପଣ ଏଇ ଯୋଉ ଅର୍ଡର ନୋଟିସ ଏସଆର ହେଲା ଆପଣ କହିଲେ ଯେ ସ୍ପେଶାଲ ପିଅନ ନୋଟିସ ଆପଣ ପାଇନାହାନ୍ତି ସେଟା that I cannot consider now in a revision application.
then your lordship may give leave for filing of
No, that leave I know that will be the last prayer that I cannot grant. ଆପଣ revision ରେ ସେ leave ହେରିକା ଦେଇ ହବନି. Had learned counsel for the petitioner at length. The petitioner is before this court challenging the ସେଇଦିନ ଯୋଉ ଦିନ ନୋଟିସ ପାଇଲେ ସେଦିନ ଆପଣଙ୍କୁ ଦେଖା କରିବାର ଥିଲା କି ଓକିଲଙ୍କୁ ଦେଖା କରିବାର ଥିଲା?
ଆଜ୍ଞା
ଯୋଉ ଦିନ ସେ ନୋଟିସ ପାଇଲେ ରିଫ୍ୟୁଜ କଲେ ସେଇଦିନ ସେ ନୋଟିସକୁ ଦେଇଥାନ୍ତେ. ଆଜ୍ଞା ଦିସ୍ ପ୍ରୋସେସ ସର୍ଭର ଇଜ ଅଣ୍ଡର ବାଉଣ୍ଡ ଇନ୍ ଡ୍ୟୁଟି ଟୁ ସର୍ଭ. Court is under a bound in duty in view of the provisions contained in Special Relief Act as well as the
ସାର୍
CPC.
ମୁଁ ଏଇଟା ଦେଖଉଛି ଆପଣଙ୍କୁ ସାର୍ ଏଠି ସେ ମନା କଲା ଏଇଟା ଦଉଛନ୍ତି ପୁଣି କିଏ witness?
ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ ଆପଣ ମତେ ଭାବୁଛନ୍ତି ଯେ ମୁଁ ହଉଛି ଏସଡିଜେ.
ନା ମୁଁ କହୁନି
ଆପଣ ଏଟା କାଇଁ ସେଠି ଫାଇଲ କଲେନି?
ସେଟା ଫାଇଲ କରି
ମୁଁ କଣ କରିବି ସେଥିରେ? ମୁଁ ରିଭ୍ୟୁ କରିବି ଏସଡିଜେମ୍ ସଫିସିଏଣ୍ଟ ହେଇଥିଲା କି ଆପଣ ସେ ଗ୍ରାଉଣ୍ଡଟା ଧରନ୍ତୁ କୋର୍ଟରେ ଫାଇଲ କଲେ ଏସଡିଜେମ୍ ସେଟାକୁ ଆକ୍ସେପ୍ଟ କଲେ ଅଦର ସାଇଡ୍ ଆସିବେ ଏସଡିଜେମ୍ ରିଜେକ୍ଟ କଲେ ଆପଣ ଆଉଥରେ ଆସିବେ ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ଥିଙ୍ଗ. କଣ ଲେଖିଲେ? Had already counsel for the petitioner, the petitioner is before this court challenging the judgment dated 3/4/24 passed in CRLP number 233 of 2022 by the Learned Judge Family Court Cuttack. The application as the present the revision application has been filed under section 401 of CRPC read with section 19(4) of the Family Courts Act. To sustain the challenge, it is submitted by the learned counsel for the petitioner that he had not received notice ସେ କଣ ଆରେଷ୍ଟ ହେଇଯାଇଥିଲେ ଯେତେବେଳେ
ଆଜ୍ଞା
ସେ କୋଉଠି ଜେଲରେ ଯାଇକି ରିଫ୍ୟୁଜ କଲେ?
ନା ନା ସେ ଆରେଷ୍ଟ ହେଲା ନୋଟିସ ପାଇଲା ପରେ ଆରେଷ୍ଟ ହେଲା ଆରେଷ୍ଟ ହେଇସାରିକି ଜାଣିକିରି ତାପରେ ସାର୍ ସାର୍ଟିଫାଇଡ କପି ଆଣିକି ଫାଇଲ କଲା ସେ ମୂଳରୁ ଜାଣି ନଥିଲା ଅର୍ଡର ହେଲା
ନୋଟିସ ପାଇକି ଆରେଷ୍ଟ କେମିତି ହେଲେ ତାହେଲେ ସେଟା ଜେଲରେ ତ ଆପଣ ସେଟା ହବନି ଯଦି ଜେଲରେ ଥିଲେ
ଜେଲରେ ଏକ୍ଜିକ୍ୟୁସନ କେସରେ
ସେଟା ବି ଆଉ ଗୋଟେ କଣ ଆପଣ ଏଇ ସବୁ କ୍ୱେଶ୍ଚନ ଆପଣ ପଚାରିବେ ଆପଣଙ୍କର ଯୋଉ କ୍ଲାଏଣ୍ଟ ଇଣ୍ଟରଭ୍ୟୁ ଗୋଟେ ଇମ୍ପୋର୍ଟାଣ୍ଟ ପାର୍ଟ ଅଫ
ସାର୍ ଏଟା
litigation.
କ୍ଲାଏଣ୍ଟ ଏ ଯୋଉ ଆଡଭୋକେଟ ବ୍ରିଫ
ଆଡଭୋକେଟ ଇଣ୍ଟରଭ୍ୟୁ
ସେ ଆଡଭୋକେଟ
ଆପଣ ଯୋଉ ପ୍ରକାର ସବୁ ପ୍ରପୋଜିସନ କହୁଛନ୍ତି ନା ତାର ଆଗ ଅଛି ନା ତାର ପଛ ଅଛି କୋଉଟା ଆରମ୍ଭ କୋଉଠି ଶେଷ ବୁଝି ହଉନି.
ଏକ୍ଜିକ୍ୟୁସନ
Anyway,
କେସ
ଛାଡ଼ନ୍ତୁ।
ସାର୍ ୱାରେଣ୍ଟ ଗଲା ପରେ ମୁଁ ଆରେଷ୍ଟ ହେଲି
ଆଚ୍ଛା ଏକ୍ଜିକ୍ୟୁସନ ଆରେଷ୍ଟ ହେଇଗଲା
ହଁ।
ରିଫ୍ୟୁଜ କଲେନି ସେତେବେଳେ ତ ସାହସ
ରିଫ୍ୟୁଜ
ହେଲା
କେମିତି କରିବି
ହଉ
ରିଫ୍ୟୁଜ ପୋଲିସ ଯାଇକି ଆଣିବ ଉଠେଇ ଆଣିବ
ସେଟା ରିଫ୍ୟୁଜ କରିଥିବେ ତାପରେ ସେଟା ପ୍ରଥମେ
ନାଇଁ ସାର୍ ଆଭଏଡ କରିବ
ବିଡବ୍ଲ୍ୟୁ ହେଇଥିବ ବିଡବ୍ଲ୍ୟୁ ପରେ ଏମ୍ବିଡବ୍ଲ୍ୟୁ ହେଇଥିବ
ସେ ଡାଇଭର୍ସ ପିଟିସନ ଫାଇଲ କରିଛି ଆଭଏଡ କାଇଁ କରିବ
କଣ ଲେଖିଲେ? Paragraph 20 of the application, at paragraph 20 of the present application, 21 of Kodia and Equisi of the application, the following has been stated regarding notice not being sufficient. the learned counsel for the petitioner refers to the certified copy of the order sheet in the CR criminal proceeding number 233 of 2022 annexed to the application marked as Annexure 3. She refers to the order dated 6/1/23 2/2/23 15/5/23 7/7/23 5/10/23 ଆପଣ କୋଉ ଯାଏ ପଢୁଥିଲେ 11/10/23 ରେ
ଆଜ୍ଞା
anyway 5/10/23 the said orders are reproduced here ଆପଣ ଏଟା Annexure 3 ରେ ପାଇବେ page 24-25 ରେ ଅଛି. The learned counsel for the petitioner is also apprised of the order passed by the learned JFC. JFC ର full form କଣ?
judicial magistrate
ସେଟା JFC ମାନେ M ଟା ନହେଲେ ଚଳିବ ଅଛି JFC କଟକ order dated 11/10/2023 9/11/2023 17/11/2023 नहीं 17/11 11/12/2023 stop para is submitted upon being apprised by this court regarding the order dated 11/12/2023 when the learned court in session of the matter observed that upon the SR revealing SR upon the service return with endorsement quote refusal of summon by OP potents and filing of the service affidavit to that effect by the petitioner. The court, the learned judge, the learned JFC had no option but to make the notice sufficient. In view of the provisions contained in the CPC जो provision था अच्छी, as well as the General Clauses Act. Though the petitioner relies on the provisions of the CRPC, the proceeding before the JFC is also guided by the Family Courts Act in view of the fact that it is an application for maintenance. The learned counsel for the petitioner further submits that the learned judge, the learned JFC could not have issued the notice through special peer. In response to the same, the learned counsel was requested to apprise if there is any prohibition contained in the CRPC or CPC. She fairly submits that though there is no prohibition for sending notice through special peer, but the court should have issued notice initially by following section 67 of the CRPC. Since repealed got selected. Since repealed are substituted by parametric provision contained in 69 of तो एटा within local limit एटा भूल आपण भी मते within local limits एटा एटा कोन outside Kotak jurisdiction 64 बोधे ठीक अछि से लाइन टा काटी दियो it would unnecessarily create confusion para
sir 64 65
outside jurisdiction
नहीं नहीं 64 का summons house sir 65 service of summons
64 आपण जते पढुचंती जेतु दीटा साइड करछनी कोटा मते स्पेसिफिक कोंतु
64
CRPC ना BNSS BNSS 64
हां
64 of BNSS on being asked whether the petitioner had refused to receive the summons and what would be the consequence. Like, on being asked when the petitioner refuses to receive the summons and what would be the consequence, the learned counsel for the petitioner submits that the petitioner has approached this court seeking setting aside of the order passed by the learned JFC stuff. In considered view of this court, once it is the SR is back and it is reported that refusal of summons by the opposite party, the learned court in session of the matter had no option but to treat the summons to be sufficient. Stuff. As per the principles contained in so and so per judice election, the petition being devoid of any merit is dismissed. It is at this stage, it is submitted by the learned counsel for the petitioner that the petitioner shall find his remedy in accordance with law. It is observed that the petitioner, if so advised, may find his remedy in accordance with law. If so, find his remedy in accordance with law. What best can be done, but maybe what you are saying, this is not the end of the last what you call last phase of the battle or the last point.
Sir, 126(2) रे हे पे.
Exactly. आपण कोण करिवे सेटा how far it will be tenable देखंतु आपण.
Sir, ए ऑर्डर टा मते टिके असुविधा हो.
आपण आसीबार नथिला. You took the risk. आपण चांस नेले. आपण जदी सेटा कले आपण एटा आपण को फुल प्रूफ केस नो आपण जोटा आर्गुमेंट करूछु दैट इज पॉसिबली करेक्ट बट लॉ तो इवॉल्व हेनी ना जे स्पेशल पियर नोटिस हेई परिबो ना आपण आर्गुमेंट आपणकर प्रॉब्लम होती कोर्ट प्रोसेस ऑर्डर आपण गोटे एक्सट्रीम आर्गुमेंट करछन इट वेरी डिफिकल्ट फॉर एनी कोर्ट टू हैंडल इट स्पेशल पियर नोटिस हेई परिबो ना आपण
ने मन्ना करूनी सर स्पेशल नोटिस
सो से जगह रे आपण जेतबेला आपण को वकील ब्रीफ आपण एंगेज करले आपण तो मना करथांते the special peer notice, the law has not developed a special peer notice, court is square. Have you marked that we are issuing notice, special peer notice?
Jodi sir, dita process re.
That is not prevalent in Odisha High Court. Can I the original side nahi? But in many cases, you'll find that the honorable judges are also issuing special. At least I have marked in during my practice days. Issue emergent notice. Amar the emergent notice kichhe nahi, amar notice khali achi. Amar special, most likely it is special messenger.
Yes, with a liberty.
Say liberty gale, I will be spoiling the right accrued to the other side. Without hearing, how can I? ଆପଣଙ୍କର ଗୋଟେ extreme proposition ଯେତେବେଳେ ଆପଣ ଯେତେବେଳେ when you are trying to propound an extreme proposition, you have to be very careful. Special peer notice ହବନି ତ କୋର୍ଟ କଣ କରିବେ ତାପରେ ଯଦି notice issue କଲେ. And interestingly, special peer notice ଯଦି ଆପଣ ହେଇଥାନ୍ତା ତାହେଲେ ଆପଣ 64 ରେ କଣ ରହିଥାନ୍ତା? Notwithstanding anything contained in any provision, the summons shall be issued. Non-obstante clause 64 नुह. आपण जोटा डिसीजन जोटा पढिले सेटा आउटसाइड जुरिसडिक्शन डिसीजन टा पढि देले.
ना आउ गोटे अछि जोटा जस्टिस महापात्रंकर केपी महापात्रंकर.
कोन अछि?
सेथरे अछि.
सेमिति कोन से डिसीजन नाही. Rather, court is a bounded. Court is under duty to observe that even आपण जोटा देखिबे सीपीसी रे अछि that CC Alavi Haji versus Palapeti Mohammed. Still, we are facing difficulty in recording that the notice has been sufficient when the petitioner files affidavit that I have not received notice before the trial court. Leave the one. Leave the one. Entire जो जहाँ भी accrue करी the other side favor that gets obliterated. Yes, आपको रहेला पासो को order कर रहे. Yes. Sir, rest of the matters आपण add कर देबे जति करू adjust कर दियो जति लेफ्ट ओवर पहिला आपण आज के आज by next 3 weeks 3 days actually this break bench will happen, so there will be the morning division bench will be continuing I think, so सेटा टिके adjustment करिवे
item 39 interim order गोटे अछि for adjournment in the सेटा
39 and interim order ठीक अछि.
35 also same. 35 also same.
Every order of adjournment kindly mention serially.
35.
Serially, sir. मैं को जाए गले मैडम पटनायक का मैटर 26
27 ଟା ପଡିଛି
27 ଟା आपण चाहिए item 28 through 32 आगे sorry कौन करो 29 रे कोन हले और ठीक अछि 29 एडजस्ट करतियो ऑर्डर्स कुछ ने आसीबो बोली लिस्ट को कर देबे मु तो कोछ इरेस्पेक्टिव ऑफ मेंशनिंग जदि आपण जोडा चाहउछंती से करि देबे अर्जन जोडा हे 29 रे डेट कर दियंतु गोटे कर देबे ठीक अछि कर देबे 30 रु 32 31 32 जाईची 30 कोते जाईची 33 रु 40
35 my lord.
35 you are Mr. Das.
My lord.
Other side अछंती की mention I don't expect थिबे बोली beyond court time.
The matter is I am for the wife mail.
Sir,
They are filing the transfer.
No, टिके one second. I am not taking up anything on merit, please.
Here, my lord.
आपण first of all date fix करो 35 टा.
Interim order is there to file adjournment.
आपण agree करनाती गोटे place of location of trial पाई. Both of you can agree and so that the matter gets closed. You must understand that it takes a lot of time to hear a matter also. If you agree, then it can be disposed of. 35 date करो तू.
वो कौन सा 3 है
Again?
3 8 हबो ना आगुर चाहउछंती आपण.
नहीं 3 8 तो.
Yes. 37. My lord. 37. I'm for the opposite party, my lord.
कोड 37 है 35 37 है.
Item 34
Just one second. 37 रे आपण कहउछंती एथिरे अछि adjournment order.
My lord, adjournment and this is part heard matter. Lordship has already heard it. Substantially, it has been
आपण
heard.
कहउछि केते Mr. Das?
37.
35 तो बोला.
37, my lord, I am mentioning. 37.
37 केबे डेट करंतु.
वो कौन से 3 है
My lord, can it be little earlier, my lord? Why bring, my lord, because
20 साते पर्यंत अछि आपनकर 350 350 टा अछि 360 टा अछि 27 सात हे परिबो आपण केते कहउचंती 3 8 रे 38 टा अछि सिपाही से कहउचंती 27 सात जदी कहबे हो
my lord,
27 सात कोन जे
Item 44 ଟା ସେଥିରେ कोन IA फाइल करछि कोन appropriate
गोटे डेट करंतु 34 टा
वो कौन है 27 7
सर कई सप्ताह 3 दिन
नहीं आफ्टर नोटिस मैटर सर आर्ट कॉलेज जो मैटर टा ऑलरेडी अछि तक तो हटई हमनी ना
सर पीडीएस सिस्टम वर्षा दिन आसे
I remember your case
लोक 5 किलोमीटर जाउछन वर्षा दिन होरान
आपण से सेकंड ऑर्डर टा को एनीवे 27 7 आसु देखियो तले 20 7 करो देखियो 20 7 20 7 it gets added to another 113 matters that is the difficult आपण को जोटा adjournment कहउतले आपण
Item 39.
adjournment अछि सेटा
Adjournment.
yes yes
3 times it has come, my lord. So I have mentioned the matter has not been released, my lord.
हबनी सर 25 मैटर टा कंप्यूटर रे आपण कोन टुपर तळ करि परिबे से जुग पळेला हमर जोटा थिला जे ऊपर तळ हे करथले से जुग कोन अछि एबे तो कंप्यूटर रे होछि सेटा गोटे दिन को दिन ओटा लिस्ट हबो कोन हबो कोन सब
But item 38, your lordship.
just one second 39 टा आपण गोटे डेट करंतु
वो कौन से 3 है
3 8
Adjournment.
20 7 ठीक अछि 20 7 रखंतु
I will pardon
ओटे ते adjournment एतरे अछि
Okay.
I will pardon me. So item 34 सर काउंटर नीचंती पिटिशन सर रिजेंडर फाइल करछ बाय दैट टाइम 20 भीतर दे
नहीं ऑर्डर डाक ऑर्डर करो सिंपली डेट मुझ once I have stopped dictating orders काहे सेटा ठीक नो yes miss Misra
My lord, item 38.
yes 38 डेट करंतु
वो कौन से 3 है
we commencing 3 8 miss Misra 41
Sir, item 39, that's it.
ये साथ adjournment आपण कहले पर हां से ऑर्डर टा करिया पड़ियो ठीक अछि मु बुझिली 35 टा और 39 फाइल काढिबे आपण 40 सर यस ଆପଣ ଚାହୁଁଛନ୍ତି 6-7 ପୂର୍ବରୁ 6-7 ପୂର୍ବରୁ କଣ ହେଇପାରିବ? Six, seven ପୂର୍ବରୁ ହେଇପାରିବ। ଦେଖନ୍ତୁ କାଲି ଆଡ୍ କରିଦିଅନ୍ତୁ ଲାଷ୍ଟ ପଟି ହଁ ପଟିଟାକୁ ଆଡ୍ କରିଦେବି କାଲି ଯାହା କହିବ ତା ପଟି but this division bench in the morning I think it will continue yes